Thank you. Mr. Chairman, Professor Stern, Professor Tawil, good afternoon. My name is Arif Ali, and I'm appearing on behalf of the claimant. Now, this may be something that only the chairman understands, and I apologize to others who may not, but in cricket, which is one of the grandest sports ever to be invented and played, the afternoon post-lunch session is often the hardest for the players, the spectators, and indeed the umpires. But it is also often the session in which much happens regarding the final outcome of the match. We are confident that by the time we're done with our presentations, the outcome of this match will be decisively tilted, if not finally decided in our favor. Allow me to thank you in advance for all of your hard work and attention to the multitude of issues that we have been putting before you on a rapid-fire basis. Let me also thank the Republic of El Salvador's legal team for their presentation of this morning. However, I, for one, did not learn anything that I already didn't know from my study of El Salvador's written pleadings. We believe we've shown you in writing why they're wrong, and we intend to do so again in the course of this afternoon and over the course of the next 2 days. As you've read in our respective written submissions and heard this morning, Respondent has put forward 4 separate objections. An objection to your jurisdiction ratione temporis, an objection on the basis of abuse of process, a request that you deny the benefits of CAFTA to claimant, and an objection on the basis that Article 15 of the El Salvadorian investment law does not contain El Salvador's unilateral consent to ICSID jurisdiction. Now, I'm going to give you just a quick synopsis of why you should reject each of these objections, and my colleagues will then, in their respective presentations, make it abundantly clear why what Respondent has said to you is just flat out wrong. But before we get too mired in details here, what's the bottom line? It is this. First, they're wrong because they're asking you to disregard the plain terms of the 2 instruments of consent that we have invoked, namely CAFTA and the Salvadorian investment law. Second, they cannot prevail because they have not discharged their burden of proof, which in the case of at least 2 of their objections is a heightened one. In this regard, you might ask yourself the following question. If El Salvador truly believed in its litany of objections, why hasn't it tendered a single fact witness in support of its objections? That is, other than its own counsel, a person who claims to have been primarily responsible for bringing the Republic of El Salvador as a client to his firm. Where is Ms. Yolanda de Gavidia? Or Ms. Gina Navas, the author of a very significant letter in December 2008 for the purposes of this jurisdictional debate? Or Mr. Guerrero, who was featured in a newspaper clipping that Respondent discussed this morning? Or Mr. Barrera, who is featured in other clippings? Or perhaps even someone who was involved in the negotiation and drafting of the investment law? They've offered you no one. Certainly no one who can speak to or deny the fact and contents of the many assurances and promises that were being given to our client from 2004 through 2008 regarding the imminent release of the required permits. No one. Let me turn to their first objection, jurisdiction ratione temporis. And let me start out by clarifying a confusion that Respondent has worked very hard to create. There is a very clear distinction between the requirements for jurisdiction ratione temporis and the requirements for establishing an abusive process. For jurisdiction ratione temporis, the relevant inquiry is whether the claims asserted by the investor claimant are based on the measure alleged by the investor and whether the measure and the resulting claims are within the temporal scope of the treaty. The inquiry for abuse of process is whether a corporate restructuring was undertaken by the claimant party for the sole purpose of gaining access to ICSID jurisdiction before there was a dispute between the host state and the investor relating to a measure giving rise to state responsibility on the international plane. We're going to be discussing this distinction with you a lot this afternoon and again on Wednesday. Respondents' argument that you lack jurisdiction ratione temporis is based on two propositions, each of which in our submission is incorrect. First, it asserts that our client is not an investor of a party because it became an enterprise of the United States only after it made its investment in El Salvador. Second, it asserts that the measure at issue is either its environmental ministry's, that is, MAN's, failure to grant a permit to Pacific Rim El Salvador within the statutorily required time period in 2004, or alternatively, that it is MINEC's failure to grant the company a mining concession in 2007, even though neither of these failures, even if they could be considered to constitute measures at all, are the measures that Claimant has alleged to constitute the breaches of CAFTA, giving rise to the claims that we have put before you. With respect to the first proposition, they pointed to nothing in CAFTA that requires an investor to first attain the status of a person of a party and then only afterwards make its investment in the territory of another party. That's because there is no such requirement. They want you to read into CAFTA a requirement that simply does not exist. As you'll hear shortly from Mr. Posner, a person that makes an investment and then becomes a person of a party qualifies as an investor of a party. Any other conclusion would not only fly in the face of the realities of international business and investment, but also of well-established investment arbitration jurisprudence, and more importantly, the plain terms of CAFTA. With respect to the second proposition regarding the measure at issue, as we've stated time and time again, and as we will again demonstrate through the presentations of my colleagues, the actual measure at issue here is the practice of the government of El Salvador in direct contravention of the country's laws to withhold permits and concessions in furtherance of the exploitation of metallic mining investments. In other words, El Salvador's de facto mining ban. This ban, this quote-unquote practice, this practice was publicly confirmed for the first time by President Saca in March 2008, and then reaffirmed several times by President Saca, his successor President Funes, and by other government officials. The acts and omissions which respondent keeps bringing up, all of which occurred prior to 2008, are not the measures on which our claims are based. Individual instances in which respondent's environmental ministry or mining bureau failed to issue permits or concessions in a timely manner may have caused delay. They may be part of the practice that constitutes the measure at issue, but they aren't necessarily the measure at issue, and certainly not just because respondent says so. Unlike the public confirmation in March 2008 by President Saca of what, in retrospect, appears to have been a long-standing de facto mining ban, these administrative delays did not wipe out the value of Claimant's mining investments, that is, cause damage, nor did they undermine the legitimate expectations that had induced Claimant to make those investments in the first place. If you were to take respondent's view to its logical conclusion, then every time an investor faces ordinary bureaucratic delay by some regulatory body or another in a CAFTA host state, you would have a measure at issue for purposes of CAFTA. The investor would be forced to immediately pursue international arbitration or risk losing access to that procedure in the event that a real international dispute with the host state eventually arises. That can't be right. Now, let me turn very briefly to respondent's abuse of process objection. Simply because when all is said and done, this objection is nothing more than a repackaging of its objection to your jurisdiction ratione temporis. Like its jurisdictional argument, its abuse argument is based on the fundamentally flawed premise that the measure at issue in this dispute is MAN's original failure in December 2004 to act on PRESA's application for an environmental permit. El Salvador erroneously contends the quote-unquote dispute was born at that moment, making PACRIM Cayman's subsequent acquisition of U.S. nationality an improper attempt to gain access to CAFTA's Investor State Arbitration Forum in order to litigate an existing dispute. As evidence of the alleged improper motive behind PACRIM Cayman's acquisition of U.S. nationality, they've attempted to highlight the supposed absence of substantial business activities that forms the basis for their denial of benefits argument. Well, we're going to be hearing a lot about the substantial business activities in a short while, as well as the reasons that underlay the company's decision to domesticate itself to Nevada. You're going to be hearing from Ms. Walter as to why you should reject El Salvador's abuse of process argument. To put it as succinctly as I can without taking away her thunder, the bottom line is that you cannot find an abuse of process if you agree with us that there was no dispute, as that term is defined and applied in CAFTA, that our client knew about or should have known about prior to the domestication of PACRIM Cayman in December 2007. And you cannot find an abuse of process unless you determine that El Salvador has satisfied its heightened burden of demonstrating clearly and convincingly that the domestication of PACRIM Cayman was done in bad faith, abusively, and perniciously to game the system. That is, to gain access to ICSID jurisdiction that it would otherwise not have had in respect of a pre-existing dispute. In our view, at the very earliest, the parties' dispute arose when our client first became aware of respondents' practice of withholding the permits necessary to carry out metallic mining. Prior to March 2008, there was no way that our client knew or could have known about this practice, that is, the de facto mining ban, particularly in light of the numerous assurances that it was receiving from a variety of quarters that the required permits were going to be issued imminently. Notably, in all of the presentations we heard this morning, not a single word was said about the promises and assurances that were made to Mr. Shrake and his colleagues by El Salvadorian government officials. Of course they wouldn't mention this because it's not very helpful for their case. Indeed, for you to settle on an earlier date than March 2008 would be patently unfair to Claimant, as it was El Salvador's own conduct that concealed the ban's existence by leading Claimant to believe that the applications of Prez and Dorex were being actively reviewed and that the government supported their mining enterprises. Venere contra factum proprium. Now, allow me to turn to El Salvador's denial of benefits objection, another extraordinary objection for which a respondent must discharge a very high burden of proof. CAFTA Article 10.12.2 permits a party to deny CAFTA's protections to an enterprise that is an investor of another party if three conditions are met. And you heard about these conditions from Mr. Badini, but let me repeat them to set up what I need to say. First, the denying party must prove that the investor has no substantial business activities in the territory of the party where it is established or of any other party. Second, the denying party must prove that the investor is owned or controlled by persons of a non-party or of the denying party. Third, the denying party must provide advance notification in accordance with Article 18.3 of its intent to withdraw CAFTA's protections from an investor of a party and must afford the investor's home party an opportunity to engage in state-to-state consultations in accordance with Article 20.4 on the proposed withdrawal of protections. None of these conditions is met in this case. Mr. Posner will soon explain to you why, but allow me again to provide you with the punchlines. As the party seeking to deny CAFTA's protections to an enterprise that is an investor of another party, and therefore presumptively entitled to those protections, let's not forget that it is respondent's burden to establish that PACRIM Cayman has no substantial business activities in the territory of any party other than a denying party. It is not claimant's burden to show that it has some quantum of substantial business activities in the United States. Article 10.12.2 requires that respondent bear the burden of showing a complete absence of substantial business activities of claimant in the US. This it clearly has not done. It has failed to rebut our affirmative evidence demonstrating that our client does in fact have substantial business activities in the United States, whether considered from the point of view of its integral role as part of the PACRIM corporate family or on its own. As scores of tribunals have done before you, we urge you to be realists and not formalists, to focus on the economic reality of the investment that underlies this dispute and not merely the corporate formalities that are the vehicles for that investment. El Salvador has also failed to rebut our evidence that the ultimate owners and controllers of PACRIM Cayman are persons of the United States. They want you to confine the own or control analysis to PACRIM Cayman's direct corporate parent, in contravention of the plain meaning of those terms. They also want you to ignore the fact that CAFTA was negotiated to allow a party to deny benefits only to enterprises that lack a real and continuous link with the territory of another party. That is plainly not the case with respect to PACRIM Cayman, a company which is not only ultimately owned and controlled by the US shareholders of its publicly traded parent, but which is also managed by Mr. Shrake, a US citizen from his office in Reno, Nevada. Again, we ask you to focus on the realities of international business and investment and not simply on the formalities. Given the object and purpose of CAFTA, is it really possible to ignore the interests of the US investors whose share value has been destroyed by El Salvador's actions? Does it really make sense to ignore the realities of Mr. Shrake's involvement in directing the activities of this investment in El Salvador and to enhance shareholder value? We think not, and we are confident that if you don't already agree with us, that you will undoubtedly do so after you've heard Mr. Shrake's testimony and have digested the presentations that you'll hear from our side. Finally, and there is no factual dispute about this, El Salvador failed to provide timely notice of its intent to deny the benefits of CAFTA to the claimant here. Its provision of notice to the United States on 1st March 2010, more than 9 months after commencement of the arbitration, and more than 15 months after claimant notified respondent of its intent to submit claims to arbitration, cannot be accepted as sufficient to deprive the tribunal of jurisdiction or to deprive claimant retroactively of protections respondent was obligated to afford claimant as an investor of a party. CAFTA Article 10.12.2, as you're soon going to hear from Mr. Posner, is crystal clear. Notification must be provided to the investor's home party before an arbitration is initiated. For you to find in respondent's favor on this point, you would have to ignore the text, context, and object and purpose of Article 10.12.2 and specifically determine that there is no consequence whatsoever associated with the fact that respondent decided to invoke the denial of benefits provision of CAFTA as an afterthought some 15 months after claimant notified respondent of its intent to submit claims to arbitration. In short, all we're asking you to do here is to apply the specific terms of the treaty. If you apply the treaty strictly, as we believe you must, then timely notice was absolutely required, and there's no dispute that this did not happen. If you decide for some reason that the text of the treaty does not call for timely notice, then you must still find in our favor, as respondent has not satisfied its heightened burden of proof with respect to its denial of benefits objection. Now, finally, just a very quick word on El Salvador's objection to our claim that it has consented to ICSID jurisdiction pursuant to the plain language of Article 15 of its investment law. Hopefully, if I have time, we have time, I'll return to this objection later on this afternoon, so I'm going to say very little about it, other than the following. In light of how strenuously El Salvador has clung to this objection, it's remarkable that they haven't put forward any direct evidence in support of their position that Article 15 was never intended to set forth El Salvador's unilateral consent to exit arbitration. The best that they've been able to do is to rely on a strained reading of one provision of El Salvador's constitution and suggest to you that you need to pass through some of El Salvador's BITs to discern what the state's intent must have been when the law was being drafted. And on this basis, they ask you to disregard the text of Article 15, which is crystal clear in providing El Salvador's consent to exit arbitration, the findings of the Encesa Tribunal affirming that El Salvador's consent in Article 15 is crystal clear, the characterizations of the Encesa Tribunal's findings on the investment law by the Mobile and Cemex tribunals, the analysis and views of noted scholars such as our friend Professor Christoph Schroer and others, the views of Dr. Oliva de Cotera, an El Salvadorian commentator on the scope and effect of the law, El Salvador's submissions to UNCTAD, an international body that serves as the focal point within the UN Secretariat for all matters relating to foreign direct investment, the presentations made on the scope and effect of the law before the Salvadoran Asamblea Legislativa, and the position that El Salvador took on the scope of Article 15 in the context of the Encesa arbitration, in which, as you have now seen, respondent affirmed that Article 15, quote unquote, certainly provided its consent to exit arbitration of claims arising under the investment law. They have no real answer to any of this direct evidence of the scope and effect of Article 15 of the investment law. It clearly contains El Salvador's consent to exit jurisdiction, and we have properly invoked that consent. Now, members of the tribunal, before I hand off to Mr. de Grammont, allow me to just make a couple of final observations, please. We have all read a lot about good faith in this arbitration, and indeed, good faith is a critical principle underlying not only the performance of the legal, political, operational, and economic obligations associated with an investment, but also in connection with dispute resolution proceedings that may arise out of that or that are related to that investment. Now, we understand vigorous advocacy. Indeed, we practice vigorous advocacy. But there is a bright line between vigorous advocacy and unnecessary advocacy or gratuitous advocacy. We believe that respondent has crossed that line. Do they truly believe, in good faith, that the chair and vice chair of a leading international arbitration practice would have been so inexperienced as to have discussed a client's business and legal strategy with a potential associate candidate in the course of a screening interview? I imagine the answer to this question will become clear tomorrow when we cross-examine Mr. Parada. In any event, let's not forget that once you brush aside all of the letter writing, the advocacy, and jousting between lawyers, what is at issue here is an investment in the tens of millions that was made in El Salvador, in the tens of millions, as well as state-of-the-art technology, intellectual property, and livelihoods, all of which were invested in El Salvador, not just by Americans and Canadians, but also by Salvadorians. Salvadoreños who needed the jobs provided by our client and who today are suffering because of politics. Our client's investments were made on the basis of assurances that PACRIM received from Salvadorian authorities, on the basis of collaboration and the hope of mutual gain. But where we are today and why we are fighting this fight in front of you and in the eyes of the many who are watching online is because of politics. If there's any doubt about that, you need only look at the statements made by President Saca, President Funes, El Salvador's Archbishop, just to name a few. That we are here before you today is because of political agendas, expediency, administrative abuse, and arbitrary and capricious conduct That much is clear. And we only ask that you allow us the opportunity to demonstrate this to you in the merits phase of this arbitration. And that, Mr. Chairman, with that, Mr. Chairman, members of the tribunal, I will close. I will now hand off to Mr. de Grammont, who will then be followed by Mr. Posner. Mr. de Grammont is going to take you through some of the critical facts, and then Mr. Posner will be addressing jurisdiction ratione temporis and also respondents' denial of benefits objections. We'd like to take a break after the jurisdiction ratione temporis portion and then continue after the break, and then it'll be Ms. Marguerite Walter on abuse of process and myself on the investment law. Thank you very much.
Thank you. As for the break, please take it whenever it's most convenient in the course of your submissions. We'll leave you to indicate the time.
Thank you, Mr. President, Professor Stern, Dr. Tawil. I've spent the past 20 minutes or so trying to come up with a good baseball analogy to offer to the tribunal on behalf of our U.S. client. So I will say that I thought Mr. Ali just hit a home run, and we still have the heart of the batting order coming up. I will be providing an overview of the facts relevant to El Salvador's objections to jurisdiction. And I'm going to you should have a binder in front of you that says...
Mine was misappropriated by one of my colleagues.
It's a presentation to accompany oral submission of claimant. Is that what you have? Oh, and in addition to slides, you should have some documents. Okay. So I will be providing an overview of the facts relevant to respondents' objections. And 3 of the 4 objections offered by respondent involve very fact-intensive inquiries. Abuse of process, denial of benefits, ratione temporis. All of these objections invite the tribunal to determine its jurisdiction based on a full examination of the record. They are meant to avoid the determination of jurisdiction based on a superficial or a partial review of the facts. The purpose of denial of benefits and abuse of process in particular is to prevent an investor with no ties to a contracting state from setting up a mere paper company in the contracting state in order to get protections to which they would not otherwise be entitled. And so it is ironic that respondent has brought these very fact-intensive objections, while at the same time asking the tribunal to decide the objections based on very narrow slices of the record that respondent has chosen to focus on. They then want you to ignore virtually everything else that's in the record before you. So before I go into the facts in detail, I'd like to take a step back and briefly look at the larger factual picture before us. And the focus of our objections... Oh, is it on your screen but not on the screen? I think as long as the tribunal can see the screen and as long as counsel can see the screen...
Give us 2 minutes because we have an obligation to make sure
yes, of course.
things are available from outside this room.
Yes.
But we'll cure it.
Thank you.
It's a small hiccup. We're now working.
Thank you, Mr. Chairman. So taking a step back, The focus of the objections is, of course, on number one, the claimant, its nationality, and the substance underlying its nationality. And number two, on the timing of dispute over the measure or measures at issue. And the second part really involves two issues. What is the measure or measures at issue? And when did a dispute over that measure or measures crystallize? Let's look first at the claimant. Now, respondent has tried to paint a picture of the investor in this case as a purely Canadian investor who transported a Cayman Island shell company to Nevada solely to bring CAFTA claims at ICSID over a pre-existing dispute. Respondent is basically asking you to pierce the corporate veil between PacRim Cayman and its immediate parent company. But they only want you to pierce a little bit of that veil. They only want you to see a very small portion of what's behind that veil. Because most of what's behind that veil entirely refutes the basic rationale underlying their principal objections. So they don't want you to look upwards to see the majority of US investors who actually own the claimant. They don't want you to look at the company's Nevada subsidiaries and their mining operation in Nevada, whose profits largely financed the El Salvadoran operations. And they certainly don't want you to look at the company's exploration center in Nevada, which is itself a Nevada corporation. That's where all the US geologists who planned, developed, and managed the El Salvador project were employed and where they were compensated. That's where they worked, that's where they had their offices, that's where they resided when they were not out in the field. So yes, the immediate parent company of PacRim Cayman is a publicly traded Canadian corporation called Pacific Rim Mining Corp. It has a small Vancouver office, which it currently shares with a number of other companies. It currently has exactly one full-time employee. I've seen it referred to in the press as the Canadian mining behemoth, Pacific Rim. It's from an article in the Boston Phoenix. This Canadian mining behemoth has never had more than 7 full-time employees in Canada, even back in the days when it could actually afford its own office there. As the publicly traded entity, the Canadian corporation's functions involve shareholder relations, accounting, and complying with US and Canadian securities laws. But the company's actual mining operations in El Salvador and elsewhere were run by the company's geologists based in Nevada. Tom Schrake, the president and CEO of Pacific Rim Mining Corp. And the manager of PacRim Cayman and the company's most senior geologist, maintained his office in Reno for all those positions, going back to when he joined the companies in 1997. And that's because Reno was the hub of the company's mining operations. That's where all the mining decisions and all of the mining plans were developed and made. And in 1997, Mr. Schrake, from his office in Reno, Nevada, directed the establishment of PacRim Cayman, the claimant in this case. It was established as a holding company to own and manage key mining assets of the company outside the US. That was its sole purpose. That is all it has ever done. From 1997 on, Mr. Schrake and the other geologists in Reno decided what assets PacRim Cayman would hold, what assets they would sell, and how those assets were managed. Those were its business activities. It didn't make widgets. It didn't sell stock. It held, disposed, and managed of assets. And all of the decisions concerning those sales, acquisitions, and management were made primarily in Reno, Nevada, by US citizens. From 2004, PacRim Cayman became the direct owner of the Salvadoran subsidiaries. And from that point on, virtually all of the company's investments were accounted for through Pakram Cayman. Yes, accounted for in the company's contemporaneous audited books and records. We submit that the bank account from which a wire transfer originated does not have any relevance to this inquiry, and I will come back to that point later. So even before Pakram Cayman was domesticated to Nevada in December of 2007, it had always been managed from Nevada. Again, the decisions about what it would hold, what it would sell, how those holdings would be managed were made by the company's U.S. executives, working out of the company's U.S. offices, and employed and compensated by the company's U.S. subsidiaries. Most of the financial capital invested in El Salvador through Pakram Cayman is of U.S. origin. Again, it came substantially from the profits of the company's mining operations in Nevada, and it came in substantial part from the equity investments of U.S. shareholders with addresses of record in the United States. And virtually all of the intellectual property invested in El Salvador originated from the geologic team based in Nevada. The team not only found enormous quantities of high-quality gold and silver, they also designed an underground mine that would have set new standards for environmentally clean mining in the Americas. So when Pakram Cayman was domesticated to Nevada in December 2007, the move reflected the economic and managerial reality of the company that had existed for years. And that's true, as Mr. Ali said, whether you look at Pakram Cayman by itself or Pakram Cayman as a larger group of integrated companies that for many years had a substantial presence in the United States, as well as a presence in Canada, and where the primary purpose of the integrated companies, the purpose for which all of these companies were working together, was to invest in El Salvador. Now let's turn to the measure at issue. And here too, respondent wants to obscure almost all the relevant part of the record. For now, I will use the word singular measure, but I will address Mr. Smith's point about measure versus measures. They want you to look only at the regulatory delays and alleged disagreements over municipal laws like the surface land ownership requirements. Query whether any of those delays or disagreements in and of themselves constitute measures under CAFTA that could give rise to a violation of CAFTA. Yes, we alleged in our notice of arbitration that those delays and constituted measures, but only in the light and context of what the companies began to learn in March 2008. So let's be very clear. The primary measure at issue in this case is the practice of the government not to grant any metallic mining application, regardless of whether it satisfied all of the regulatory requirements, even if it surpassed the requirements, even if it provided for the best possible mine, the best environmental safety standards, the application would not be granted. Prior to March 2008, the companies recognized that there were delays, bumps, even political opposition in some quarters of the country. But they had no reason to believe that the basic regulatory framework under which they had invested over $77 million of the country was going to be effectively scrapped or even suspended for a period of multiple years. The evidence first began to emerge. The dispute first began to crystallize in the public statement of President Saca in March 2008. And this morning, El Salvador's lawyers repeatedly limited their comments to the March 2008 press report. They said that that's all we rely on. That's absolutely not the case. Let's look at that statement, and let's look at the subsequent statements by President Saca, as well as by President Funes and members of his government. So here are the statements of President Saca And you will see that the statements become increasingly clear and definitive over time. So in March of 2008, the article that was much discussed by the respondents' lawyers this morning, President Saca said, "What I am saying is that in principle, I do not agree with granting pending mining permits." This is July 2008. For now, I will not grant mining permits. This is still long before the notice of intent was filed. The notice of intent was filed in December 2008. 2 months later, President Saca says, quote, "As long as Ilyas Antonio Saco holds the office of president, he will not grant a single permit for mining exploitation, not even environmental permits, which are prior to the permits given by the Ministry of the Economy." Let's take a look at the statements by his successor, President Funes. It's December 2009. Quote, "The government is not approving any mining exploration or exploitation project." January 2010, "No mining exploitation projects will be authorized. I do not need to pass a decree for such authorization to be given, since that would be questioning the president's word. The authorization of mining exploitation projects is not included in either in the governmental programs or in the 5-year plan. With the president's word, the mining laws of El Salvador ceased to operate." The next is a quote from an article attributing and quoting the following statements to Héctor Dara, the Minister of the Economy. Quote, "What the government has done is to provide continuity to the decision to not issue mining permits, which was made during the administration of Antonio Saco. I want to clarify that we are engaged in an arbitration proceeding due to a decision made by the previous government. Although the officials are different, we share the responsibility." So there is no doubt. Indeed, it is widely held public knowledge in El Salvador that El Salvador has implemented this practice. It doesn't matter whether the applications meet or don't meet the requirements of Salvadoran law. It doesn't matter whether an application far surpasses those requirements. It doesn't matter whether the application is revised. An application could be revised a dozen times. It could be revised 100 times, and it will not be granted or even acted upon pursuant to this practice. And indeed, since the March 2008 statement by President Saca, no metallic mining permits for extraction, whether environmental permits or extraction concessions, have been granted. Now, President Saca had said in one of his earlier statements that no permits would be granted pending a rewriting of the mining law and a nationwide study of the pros and cons of mining. Here we are, more than 3 years later, and none of the laws have changed. They've simply been ignored and unenforced. A nationwide study has apparently begun long after we filed this arbitration, long after President Saca left the government. But that only started after El Salvador lost its first round of objections in this case. To the extent that the study has yielded any findings, they haven't been made public. The de facto mining ban remains in place even as respondents' counsel repeatedly deny its existence. And whether you call it a de facto ban or a temporary ban or a moratorium or whatever, it is a practice that has been put in place by the government of El Salvador. It is a practice that is entirely inconsistent with the existing laws of El Salvador. It has been implemented outside any sort of legal framework, simply by the word of the president. The word of the president. It is a practice that violates CAFTA and violates the investment law of El Salvador, and it is a practice that has destroyed Claimant's investment in El Salvador. It is entirely different from regulatory delays. Those delays take on significance only in the context of those subsequent statements. Now, determining when the government put that practice into place is not an easy question to answer. As we'll explain, it's not an important question either. But the tricky part is that President Saca appears to have put the practice in place for political reasons, but at the same time, President Saca didn't want the practice to lead to an international arbitration. So while President Saca started publicly discussing the practice in March 2008, he and his officials were also telling the companies not to worry. It's just all political rhetoric. And apparently respondents' counsel are still operating under the same instructions. What's particularly remarkable is that even as President Funes and his officials freely admit that the practice is in place through numerous public comments, respondent in the context of this arbitration has consistently denied it. Now, as my colleague Mr. Posner will explain in greater detail later, the tribunal doesn't have to decide when the practice was put in place, particularly in the context of this case where respondent has done everything it can to hide it. The relevant inquiry is the practice continuing? And when did a dispute involving that practice crystallize? There is no evidence that Claimant knew or should have known about the practice until President Saca announced it in March 2008. Claimant didn't actually complain about the practice until April 2008 when Mr. Schrake wrote a letter to the President Saca to ask about the practice and to first invoke the protections of CAFTA. Even after that, President Saca tried to deny the existence of the practice, and we submit that the respondent should be stopped from arguing that Claimant knew or should have known about a practice that respondent has repeatedly denied, even into this arbitration. But under any analysis, even the analysis most charitable to respondent, Claimant had no reason to know about this practice until at the earliest, March of 2008. So that's the big picture. It's based on record facts that are entirely unrebutted by respondent. Let's turn to the specific details. And I know that these details are set forth at length in our written submissions, including the 4 separate witness statements and the numerous exhibits that we've provided to the tribunal. My colleagues will be discussing those further in the context of the legal arguments offered by respondent, but we thought it would be helpful to walk the tribunal through the key facts and chronology, with a particular focus on 1, the actual substance underlying the claimant, 2, the period of regulatory delays, which are not the measure or measures at issue, and 3, what the measure is and when a dispute concerning the measure crystallized. So let's start at the beginning. The current management of the company dates back to 1996, when Catherine McLeod Seltzer took over the Pacific Rim Mining Corp. Ms. McLeod Seltzer is one of the most successful mining financiers in Canada, and yes, she is Canadian. Her grandfather was a gold miner in Canada. Her father left high school during the Great Depression to work as a gold miner in Canada. Unlike her father and grandfather, Ms. McLeod Seltzer did not become a miner. She went on to college and into the world of mining finance. And just about everywhere Ms. McLeod Seltzer has gone, she has created remarkably successful mining companies, while also building hospitals, medical clinics, and schools in the local communities. And the goal of the companies in El Salvador was perfectly clear: to create a mine, a gold mine that would create new standards for environmental mining, that would make profits for the shareholders, and that would contribute significantly to El Salvador. And I will note that even though the companies have not made a penny in El Salvador, even though they have not been allowed to extract any minerals, they have helped to remove tons of refuse from the local river system. They established environmental education programs in the local schools. They funded health services and adult literacy programs. They established the first recycling program in the area. They planted over 50,000 trees. And they created more than 200 jobs in one of the poorest regions of the country, jobs that have now been lost. And we think it is noteworthy that respondent has chosen not to cross-examine Ms. McLeod-Seltzer on the witness statement that she submitted in this arbitration. Now, as set forth in Ms. McLeod-Seltzer's witness statement, her expertise is in finance, not geology. Her model has been to lead the financing efforts of her companies. She then finds a highly talented exploration geologist to actually lead the day-to-day mining operations of the companies. And in 1997, she hired Mr. Shrake to run Pacific Rim. Now, Mr. Shrake had lived and worked for many years in Reno, and one of the conditions of his accepting the job was that he be allowed to set up his office in Reno. He hired an office manager, and he started to hire the geological team, which consisted of all U.S. citizens living in the Reno area. He also set up several new companies. First, he set up the Nevada company that is now known as Pacific Rim Exploration. That's in the right-hand corner of your slide. And since 1997, that Nevada entity has served as the company's exploration arm. It's the entity that employed and compensated all the senior geologists, including Mr. Shrake. It's also the entity that developed and paid for much of the intellectual property that was sent to the El Salvador project. Mr. Shrake also directed the establishment of PACRIM Cayman to hold the company's non-U.S. assets, which at the time were all in Argentina. Now, this structure that you see on the left hand of your screen is not unusual for an international company, even a small one. It's sometimes called the Cayman sandwich structure. It's typically used by companies that have assets or plan to have assets in multiple locations. And the idea is that if you want to sell the assets in, say, Argentina, to invest them in, say, El Salvador, you sell off the bottom Cayman entity. The proceeds of that sale go only to the top Cayman entity, which then reinvests the money elsewhere. The Canadian parent doesn't pay taxes on the transaction since they're invested elsewhere. And that's basically why this is done. Now, it does not make sense, as I will discuss a little bit later, it does not make sense to have a structure like this if you were a company that is basically focused on one single foreign asset. But from 1997, PACRIM Cayman was part of the companies. Mr. Shrake from his office in Nevada decided to set up PACRIM Cayman to hold the company's non-U.S. assets. And again, from 1977 on, from his office in Nevada, Mr. Shrake decided what assets PACRIM Cayman would hold, what assets it would sell, and how those assets would be managed. So, for example, in 2001, when the companies were preparing for their merger with the Dayton Mining Company, Mr. Shrake wanted to raise cash to immediately invest in El Salvador. So Mr. Shrake directed that PACRIM Cayman's indirect holdings in Argentina be sold. The proceeds from that sale were then invested in El Salvador. Now, in 2001 and 2002, Mr. Shrake led the merger with Dayton. And the main purpose behind the merger was that Pacific Rim wanted to acquire Dayton's assets in El Salvador. Mr. Shrake believed that the El Dorado site, which was then owned by Dayton, and Dayton had the exploration permits for it, was exactly what the company was looking for. It was a low sulfidation deposit, meaning that it could be mined in a very environmentally benign manner and also with low costs. Mr. Shrake also believed that Dayton had significantly underestimated the gold reserve at the site. He believed that he and his geological team could develop the site into an extremely successful gold mine and that it would be profitable for the shareholders of the company, even at the low price at which gold was trading back in 2002. It would also generate jobs and enormous economic benefits to one of the poorest regions in El Salvador. In addition, it would create enormous revenue for the country as a whole. If the mine were operating today, it would likely be one of the largest taxpayers, if not the largest taxpayer, in El Salvador. Now, another benefit of the Dayton merger was that Dayton owned 49% of the Denton Rawhide gold mining operation near Fallon, Nevada. Mr. Shrake wanted to use the profits earned from the Nevada mining operation to help finance the El Salvador project. So, as a result of the merger with Dayton, the companies changed significantly. First of all, in addition to the Reno office, in addition to Pac Rim Exploration, they now had a significant operating asset in the U.S. Indeed, the Denton Rawhide mine was the only asset in the companies to generate income. Now, if you look at slide 9, that's a chart from the 2002 annual report, you will see that beginning in 2002, or as of 2002, as a result of the merger, the companies now had significantly more assets, property, and revenues, in the United States than in Canada.
Sorry to interrupt you, but do you have an exhibit number for this? If not, you can give it to us later.
It is part of the 2002 annual report, which is, can someone find me an exhibit number? And we'll get back to you with that, Mr. President. Second, as a result of the merger, the companies now had a majority of U.S. shareholders and started to be traded on the American Stock Exchange as well as on the Toronto Stock Exchange. Third, the primary focus of the companies was on El Salvador. And from 2002 on, virtually all of the company's money and resources were devoted to El Salvador. And most of that money and resources originated in the United States. And this is all clear from the company's public filings. Let's take a look at for example, at the 2003 annual report. That's tab 15 of your binder. Mr. President, for the 2002 report, the exhibit number is C28. Now, respondent has always argued that it thought it was dealing with a purely Canadian company. Mr. Smith said this morning there was, quote, never a hint that they were dealing with anything other than a Canadian company. Now, Mr. Shrake has given unrebutted testimony that officials of the Salvadoran government visited him in Nevada to tour a Nevada mining site. But you wouldn't have to travel to Nevada to understand that the investment in El Salvador was a substantially U.S. investment. You'd simply have to look at the company's public filings. So let's look at the 2003 annual report. And if you turn the very first page under the heading Corporate Profile, it says, quote, Pacific Rim utilizes cash flow from its 49% interest in the Denton Rawhide gold mine in Nevada to explore, define, and advance its El Dorado and La Calera gold projects in El Salvador. Also, down at the bottom of this page, you'll see a very nice picture of Mr. Shrake, who is identified as, quote, Tom Shrake, CEO, USA. On page 2, it says, quote, Pacific Rim's cornerstone asset is the El Dorado gold project, unquote. And this annual report and all those that followed make it very clear that pretty much all of the company's resources are going into El Salvador. Over on page 3, you have a picture of Bill Galen, Exploration Manager, USA. Mr. Galen was a U.S. citizen who worked out of the Reno office. He later became the Vice President of Exploration and now serves as the President of Pacific Rim, El Salvador. He still maintains an office in Reno and is compensated by Pac Rim Exploration. If you turn to page 5, you'll see a section on the, quote, Denton Rawhide Gold Mine, Nevada. And again, it says, quote, Pacific Rim's share of the cash flow from the Denton Rawhide mine will be used to fund the company's ongoing exploration efforts and corporate expenditures. And again, nearly all of those efforts and expenditures from 2002 on were devoted to El Salvador. Down at the bottom of page 5, you have a picture of David Ernst, quote, Chief Geologist, USA, unquote. Mr. Ernst is also a U.S. citizen who maintains his office in Reno and who was also compensated by Pac Rim Exploration. If you turn to page 25, which is the second to last page, you will see that the companies list their exploration office in Reno, Nevada. They have Dorsey and Whitney as their U.S. counsel. And you will find substantially the same information in all of the subsequent annual reports. So it was no secret that this investor and its investment in El Salvador had a substantial and continual U.S. presence and connection. Sure, it had a Canadian parent at the top of its corporate organization chart. Yes, it had a small office in Canada, which served several important non-mining functions. But the notion that this was just a Canadian investor that abused the corporate form by setting up a shell company in the Cayman in Nevada when it had absolutely no connection to the United States, that is just plainly false. It's refuted by even a cursory review of the publicly available evidence. Now, also as a result of the Dayton merger, the companies had a very complex and unwieldy corporate structure in 2002. Here it is in Exhibit 54, which is now up on the chart. And by the way, there's a typo in the original Exhibit 54. It should say that Dayton Mining holds 49% rather than 100% of the Denton Rawhide joint venture. Now, as detailed in the witness statements, this structure is messy and nonsensical in many respects. But since the companies were primarily focused on their exploration activities in El Salvador, they only took steps gradually and over time to clean the structure up. In 2004 and 2005, the companies made a number of changes. First, Kinross El Salvador was renamed as Pacific Rim El Salvador. Second, the companies sold their Chilean assets in 2005. They did that by selling DMC Cayman, which is the structure up in the middle, and all the subs underneath it. And all of that money was reinvested in El Salvador. And by the way, since they had used the Cayman sandwich structure, there was more money to be invested in El Salvador than there would have been otherwise. Third, Press in 2004 was moved under Pac Rim Cayman. And when Dorex was created in 2005, it also became a wholly owned subsidiary of Pac Rim Cayman. Okay. Oh, finally, the Dayton acquisition and its subs were dissolved, leaving more or less a structure that looks like that. Have the next chart. Okay. This is a complicated chart, and even for me to explain it takes a little bit of time. This chart shows Pacific Rim Cayman, Pac Rim Cayman, and their U.S. and Salvadoran subsidiaries prior to December 2007. And the chart is designed to show the origin and flow of investment from the companies into El Salvador. So to the top left of the chart, you have the individual U.S. shareholders who owned between 60 and 70% of the companies, depending on the time frame. And you have their equity investments going into Pacific Rim Mining Corp. Pacific Rim Mining Corp, in turn, invested money into Pac Rim Cayman, starting in 2004, which in turn invested the money into Press and Dorex. Now, you also have monies going from Pacific Rim Mining Corp to Pac Rim Exploration, which in turn paid the salaries of the senior geologists working in El Salvador, and that included the salaries for Mr. Fred Ernest and Bill Galen, both U.S. citizens who served successively as the president of Pacific Rim El Salvador. Again, they were both employees of Pac Rim Exploration, and both had offices in Reno as well as in El Salvador. Over to the left, you have Dayton Mining US. Dayton took the profits from the Denton Rawhide mine and sent most of it to Pacific Rim Mining Corp in Canada. Pacific Rim Mining Corp then invested that money through Pac Rim Cayman and into El Salvador. Now again, by the way, Dayton Mining US is purely a holding company. It doesn't have any employees, it doesn't have an office, it doesn't have a website, it doesn't have a chair. And yet, from Nevada mining operations, it generated $20 million, all of which was invested into El Salvador. So Dayton Mining transferred some of its profits directly to Pac Rim Exploration, as detailed in our written submissions. Pac Rim Exploration contracted with and supervised many of the paid outside consulting and engineering firms who were working on the El Salvador project. And in our exhibits, you will see numerous of those vendors' contracts requiring the invoices to be sent and paid out of Reno, Nevada. So Dayton Mining sent monies to Pac Rim Exploration, which in turn paid the outside firms that it was working with to design and plan the El Salvador project. Now, Mr. Krause, the company's CFO, explained all of this capital flow in his witness statement. Respondent chose not to cross-examine him. As Mr. Krause explained, all of this capital flow was recorded in the company's contemporaneous books and records. And if you look at tab 16 of your binder, that's the chart that Mr. Bedini looked at with you earlier this morning. I can represent that these were part of the company's audited consolidated financial statements. If Mr. Krause had been there, he had been here today, he would tell you that. I'm not going to go through this in any sort of detail, but the tribunal can see that beginning in 2004, both Pacific Rim Mining Corp and Pac Rim Exploration invested substantial money in El Salvador through Pac Rim Cayman, both in the form of loans and equity investments. Now, the reassignment that Mr. Bedini spoke of was in 2005, when the prior investments and loans were reassigned to Pac Rim Cayman. As Mr. Krause explained, all of the subsequent direct capital investment after that was made through Pac Rim Cayman. And that's how they are accounted for in the company's books and records. Now, books and records maintained by certified accountants, according to general accounting standards, are how modern companies keep track of money flows. It's how they pay taxes. It's how they comply with securities laws. The bank account from which a wire transfer originates doesn't mean anything. It could have been wired from Timbuktu if it was Pac Rim Cayman's money. If it was accounted for through Pac Rim Cayman, it was Pac Rim Cayman's investment. And by the way, nearly all of these investments were registered in El Salvador's Office of National Investment as having been made by Pac Rim Cayman. And we'll look at some of those documents.
Can I interrupt?
Please.
I take it this document is not being transmitted. It's a protected document.
We originally designated it as protected. I don't think we have any objection to undesignating it if that would make life easier for the tribunal.
I don't think it makes the life difficult for the tribunal, but we don't want to transmit to the wider world a document that you wanted to have redacted and protected. At the moment, I don't see it up on the screen, but I'm not sure whether it's not being broadcast.
I'm sorry, we did not put it up on the screen.
Oh, you did not?
We gave it to you only in your binder.
No, okay, that's fine.
Okay. Thank you for asking, Mr. President. Now, in addition to the financial capital, as I mentioned, you have the intellectual property contributed by Pacific Rim Exploration. A mine property is valuable only if you invest the intellectual property to find the minerals. The El Dorado site is an incredibly valuable site, but that's only partially because of the enormous high-quality gold and silver that has long existed beneath the surface. What has actually made the site so valuable is the intellectual property that went into finding and delineating those deposits. And at today's gold prices, with the amount, remember in 2002, gold was trading, what, under $200, $400, $270? It's now trading at $1,500. And at today's prices, with the amount of resources that the companies have delineated, the market value of the El Dorado site is worth hundreds and hundreds of millions of dollars, probably in excess of $500 million. And since mining projects are measured by since the market value is measured by the multiple of the project margin, and since the price of gold has soared and the cost of extraction haven't significantly increased, the market value is enormous. And so the contributions of all these different investors in Nevada, the U.S. shareholders, Canadian shareholders as well, these companies and investors together created a property, an investment that is far in excess of the $77 million originally invested. We'll get to this later, but that's why the proper measure of damages is not the money invested, not the financial capital invested, but the market value. That's how you measure an integrated investment like this one. Okay, let's turn to the December 2007 restructuring. In 2007, the companies were waiting for their environmental permit and extraction concession for the El Dorado site. They had considered their application for the extraction concession for the they had considered their application for the environmental permit to be complete when they submitted their plan for a water reservoir and treatment facility in December 2006. That facility would have significantly increased the amount of clean water available to local residents. Also in 2007, the companies were continuing and increasing their exploration activities at El Dorado and delineating significant new gold deposits at El Dorado. They were also making progress with Marne on their applications for environmental permits for exploitation at other sites, specifically Waco and Pueblos. You'll recall from the first round of objections that in 2004, when Press was preparing to submit an application for an exploitation concession at El Dorado, Munich expressed concern that the property was too big. And so with Munich's blessing, Press carved out the Waco, Pueblos, and Huacuco site, and Dorix was created to hold the license for those sites. Now, the focus of the discussions we heard from respondent were entirely on El Dorado. The fact was that throughout 2007 and into early 2008, progress was being made with Marne on the environmental permits for these other sites, again leading the claimant to believe that the progress was going slowly, but that the progress and the regulatory system were still in place. And indeed, the companies had been increasing the level of their investment in El Salvador throughout 2006, 2007, and into 2008. At the same time, they were also looking for ways to save money. Their expenditures were increasing, and the cash flow from Denton Rawhide was beginning to dry up. The companies were also preparing for a private placement financing in early 2008, as Ms. McLeod-Seltzer described. And so for all of these reasons, the companies were looking for ways to save money. And they were looking at ways to continue the simplification and the cleaning up of the corporate structure inherited from the Dayton merger. So here's Exhibit 55. That's the corporate structure of the companies immediately prior to the December 2007 organization. Now, first of all, the entities under PAC-RIM Caribe in Mexico and Peru had been completely inactive for years. Yet the companies had been paying the various annual fees for these entities, including PAC-RIM Cayman Caribe, to continue as active companies. In addition to fees, you have to pay lawyers and accountants in the Cayman Islands. It's not a lot of money, but there was no reason to keep paying it with no commensurate benefit or no benefit at all. So the companies decided to dissolve PAC-RIM Cayman Caribe and the Mexican and Peruvian subsidiaries. Second, the companies decided to domesticate PAC-RIM Cayman to Nevada. Again, the companies had been paying fees to maintain PAC-RIM Cayman as a Cayman Islands entity. The whole reason behind setting up PAC-RIM Cayman as a Cayman Islands entity was to realize tax savings in the event that any of the underlying assets were ever sold. Now, in this period, questions arose as to whether the Cayman Island status would in fact continue to provide tax savings in the event that the underlying assets were ever sold. As everyone knows, the Cayman Islands, fairly or not, have come under increasing criticism for being a tax haven. They've been placed on various blacklists by various countries. Moreover, the companies had no plans to sell the Salvadoran subsidiaries anytime soon. At this point, they were focused entirely on their project in El Salvador. They could save fees by domesticating PAC-RIM Cayman to Nevada, and there would be no adverse tax consequences. Now, domestication is a term of art. It's a legal term under Nevada law. And as you can see from tab 25 in your binder, those are the articles of no, I'm sorry, this should be the articles of domestication, and we'll get you the exhibit number for that. They refer to the Nevada domestication statute, and that statute's designed to encourage bringing offshore companies to Nevada. Under the statute, the company continues to exist under the laws of Nevada as though it had always been a Nevada company from the date of its original incorporation in the other jurisdiction. It's cheap and it's easy. In fact, it is cheaper and easier than maintaining PAC-RIM Cayman as an entity of the Cayman Islands, especially if you already have a presence in Nevada, if you already have lawyers and accountants in Nevada. Last, but by no means least, as Mr. Schrake describes in his witness statement, he wanted the companies to be in the best position possible in the event that a dispute with El Salvador ever arose. Again, as of late 2007, the regulatory process seemed to be moving forward, albeit slowly and with bumps. The companies were still being told that their El Dorado permits would be forthcoming. Amendments had been introduced in the Salvadoran legislature that would have clarified the land surface ownership issue, and Mr. Schrake had been advised that those amendments were likely to pass. The process seemed to be moving forward with respect to the company's other sites. At the same time, Mr. Schrake knew that there was political opposition out there. He knew that there were competing amendments that had also been introduced in the legislature that would have banned mining in its entirety. There were elections coming up, which included the possibility of a change in the ruling party. And as Mr. Schrake testified in his statement, he did not think it likely that any anti-mining legislation would pass. He did not think that the ARENA party, which had been in power since 1994, was going to lose its elections. He believed the permits were going to be granted. But in the event that something were to go south, if something bad were to happen, and if a dispute were to arise, he wanted the companies to be in the best position possible. Now let's look at the structure that existed prior to December 2007, which is set forth in Exhibit 55. And if the companies had believed they had a dispute in December 2007, they would have had recourse to CAFTA claims at ICSID. Both Pacific Rim Exploration, Inc. and Dayton Mining US had made substantial indirect investments in El Salvador. Again, all of Dayton's profits, approximately $20 million, had been invested in El Salvador. Pac Rim Exploration also made substantial indirect investments in El Salvador. The companies could have also sought to mobilize a number of U.S. shareholders to bring a claim. Pac Rim Cayman could have brought a claim at ICSID under the investment law. The Cayman Islands are covered by the ICSID Convention. And Pacific Rim Mining Corp could have brought a claim under the investment law at the ICSID additional facility. The companies could have filed multiple arbitrations in multiple fora against El Salvador. Those facts are certainly relevant to the abuse of process objection. But the domestication of Pac Rim Cayman meant that in the event that a dispute with El Salvador arose, if one crystallized, the claims of these various entities and individual investors could be brought in a single proceeding at ICSID under CAFTA. There is no doubt that if the different entities and investors had brought multiple claims in multiple fora, respondent would have argued that that was an abusive process. But we'd also ask the tribunal again to consider what sort of CAFTA claims could have been brought in December 2007. For delays? For what respondent calls a presumptive denial of the El Dorado applications? For a disagreement about the land surface ownership? Now, what about for a practice of not granting mining applications regardless of whether the applications met the regulatory requirements? What was the evidence of that in December of 2007? El Salvador's officials said those permits would be forthcoming. Marne appeared to be moving forward on the other applications for the other sites. As stated in the witness statement of Ms. McLeod-Seltzer, the companies were sufficiently confident that they were going to get their El Salvador concessions that in early 2008, they conducted a private placement financing in order to finance the anticipated exploitation concession. Now, I will also observe that in connection with that financing, the companies had a duty to disclose anything that would materially affect the company's financials. A dispute of this nature would have been material. And I'd ask you to take a look at the board of directors of Pacific Rim Mining Corp. They include some of the most prominent and experienced people in the mining business, including the former CEO of Placer Dome, as well as Ms. McLeod-Seltzer. And I'd ask the tribunal to consider whether it is reasonable to believe that any of these people would have risked their reputations, their careers, and their livelihoods by failing to disclose a dispute of this nature if they had actually thought one had existed. And I'd ask the tribunal to consider this. If the companies domesticated Pac Rim Cayman to Nevada in December 2007 for a pre-existing dispute, why didn't they start the arbitration right after that? Why did they wait for a year before submitting their notice of intent? Why did they wait for 5 months after that until April 30th, 2009 before actually commencing the arbitration itself? That was nearly a year and a half after the December 2007 domestication. The reality is that in December 2007, there was no real evidence of the de facto mining ban that's at issue in this arbitration. There's no evidence that the companies believed that the de facto ban existed as of December 2007, and there's certainly no evidence that a dispute concerning that practice had arisen. Mr. Chairman, may I have a moment to confer with Mr. Ali? Thank you. And by the way, there is no evidence that claimant concealed the change of nationality, as respondent has repeatedly alleged. If you look at tab 18 of your binder, you will see that the claimant duly informed the Salvadoran government of the change. The last page reads, and this is in the English translation, this is from Bill Galen, the president of Pac Rim El Salvador, to the National Investment Office. I hereby request that this office update the information in its registries related to the name and nationality of the company that until December 13th, 2007 existed under the name Pac Rim Cayman and operated under the laws of the Cayman Islands. Since that date, and in accordance with Section 92A 270 of the revised statutes of the state of Nevada, United States of America, the company originally from the Cayman Islands, was reorganized in the state of Nevada, adopting the nationality of the United States and also changing its name to Pac Rim Cayman, LLC. As proof of this, I attach a certified copy of the translation of the Articles of Domestication, a legal term used in the United States of America, specifically in the state of Nevada, to refer to the reorganization in that jurisdiction of companies from another jurisdiction and the Articles of Organization pursuant to the laws of the state of Nevada. Tab 19. The exhibit number. Someone's going to have to help me with this.
I think at some stage it would help us if you went through this bundle and just gave us informally by an email the corresponding exhibit numbers. But let's not worry about it now. I have another concern because I don't understand why a company has changed its name from Pac Rim Cayman LLC to Pac Rim Cayman LLC.
No, I think it was Pac Rim Cayman to Pac Rim Cayman LLC.
It's the LLC that was added.
The LLC was added because it was
I see.
a limited liability corporation in Nevada. And at tab 19, and this is exhibit 3 to our notice of arbitration, you will see the resolution by the Ministry of Economy, by MENEC, updating the name of and nationality of Pac Rim Cayman, domiciled in the Cayman Islands, to Pac Rim Cayman LLC, domiciled in the state of Nevada, United States of America. Again, this is an exhibit to our notice of arbitration. Notwithstanding that evidence, counsel has repeatedly represented that we concealed this change of nationality from El Salvador and from the tribunal. The opening of their reply says, we uncovered this concealment. There's been no concealment. All of this is in the public record. I would ask the tribunal to consider who is being cynical and who is being candid with the tribunal. Okay, let's walk through the regulatory history, through the chronology of the regulatory process, and put the reorganization of December 2007 in the context of what was happening in El Salvador at that time. Let's even put the process in the context of the alleged presumptive denial of the application that respondent relies upon so heavily. And the theory respondent offers is that after claimant submitted its application and the government failed to respond within 60 days, or 30 days apparently with respect to the concession application, the application was presumptively denied. Now, as we explain in our written submissions, the doctrine of administrative silence under Salvadoran law is designed to protect the applicant. It enables the applicant to seek recourse at the applicant's election if the government fails to take the administrative action. It's not meant to be a weapon used by the government or as a sort of statute of limitations. If you don't appeal in 60 days, you're done. Under the Constitution of El Salvador, could we put that slide up? Every person has the right to petition the legally established authorities, to have those petitions resolved, and to be notified of the decision. So the doctrine of administrative silence does not act as a sort of 60 or 30-day limitations period. It is not meant to deprive the applicant of rights. It's meant to protect the applicant. But even if the tribunal were to conclude in this jurisdictional proceeding that Salvadoran law provides otherwise, and that this is a sort of 60 or 30-day limitations period, the record facts still don't remotely support respondents' theory. Let's take a look at the sequence of events. And let's go back to September of 2004. And as described in our witness statement, during the first several years of this process, Claimant and the government were working closely and cooperatively. They were in constant consultation. And so in December 2004, Press first submitted its Environmental Impact Assessment, or EIA, for the El Dorado site. Now, according to El Salvador, when Marn failed to rule on it within 60 days, it was presumptively denied. And there we see the presumptive denial in November of 2004. Now, if that's the case, how does El Salvador explain all of the activity that follows? Neither the claimant nor anyone in the government of El Salvador appears to have recognized this so-called presumptive denial. In December 2004, Mr. Ernest wrote to Marn, and he said, and the respondent showed you the letter, 60 days has passed. What's happening? Can we have a meeting? In December, also in December of 2004, Press submits the El Dorado concession letter, but without the environmental permit. That was also done in consultation with MNEC. And in March 2005, Marn begins an extensive notice and comment period and an extensive exchange of observations and responses that continues for well over a year until October 2006. Marn poses questions about the EIA, Press answers them, Marn asks for more questions, it's published in the newspaper, public comments are received. Why engage in that elaborate process if there's been a presumptive denial? Now, also during this period, and around March 2005, as the tribunal will remember probably all too well from the first round of objections, Ms. Navas, the director of the Bureau of Mines, first informed the companies that some officials at MNEC believed that the mining law required ownership or control of the entire land surface overlaying the concession area. And as we explained in the first round of objections, Press had several options. Press could have immediately revised the application to cover a smaller concession area. Again, Press had done that previously with Huaco and Huacuco and Pueblos. Or Press could have sought clarification of the issue through a definitive interpretation or a legislative amendment clarifying the issue. Press chose the latter course. It was engaged in the notice and comment period with Marn at the time, and there was no reason to revise the application at that time. But again, with respect to the issue of presumptive denial, why would MNEC have engaged in this whole exchange about the land surface issue if the application for the environmental permit had been presumptively denied? In October 2006, Press and Marn completed the exchange of observations and responses. In December 2006, Press submitted its proposal for the water treatment facility at El Dorado. And as the tribunal will also recall from the first set of objections, and as Mr. Smith, I believe, mentioned this morning, in October through December of 2006, there was an exchange of correspondence between Press and Ms. Navas. Ms. Navas asked for various application materials, and Press provided them, again, except for the environmental permit. Ms. Navas had asked for those materials in October 2006. In a November 2006 letter, Press had submitted all of them, again, except for the environmental permit. Press also explained why it was unable to submit the environmental permit and asked MNEC to excuse its absence on the basis that there was an impediment with just cause. And in December 2006, Ms. Navas submitted a letter saying that Press had partially complied with her previous request, except for the missing environmental permit. Now, as the tribunal may recall, the respondent claimed in the first round of objections that Ms. Navas's December 2006 letter had been withdrawn. Mr. Smith showed this letter this morning, and he had a bullet point that said Press did not respond. The allegation that El Salvador offered was that the letter had been withdrawn. Now, that's a fact that remains unresolved and which the tribunal certainly doesn't have to consider at this juncture. But again, why would Ms. Navas have been asking for all these application materials if there had been a presumptive denial of the environmental permit? Why would she have written that letter? Why would she have engaged in any of this correspondence? Which leads us to the alternative presumptive denial that respondent alleges in 2007. So according to respondent, if the application for an environmental permit wasn't denied in 2004, then alternatively it must have been presumptively denied in January 2007. Here the theory is that, I think, is that press's submission of various materials requested by Ms. Navas and its request to excuse the absence of the environmental permit seems to have triggered either a 30-day, a 30-day time within which to respond. And after 30 days of silence, according to respondent, the application was again presumptively denied. So was there a dispute under CAFTA at that time? Should Dayton Mining U.S. Or Pacific Rim Exploration or the U.S. shareholders have filed a CAFTA arbitration action? Again, let's look at the facts. From Claimant's perspective, all it needed with respect to the El Dorado concession was the environmental permit. To the extent that there was an open question with the land surface ownership issue, the companies were willing to wait and see what happened with the pending amendments to the mining law. And again, if the amendments didn't pass, they'd revise the application. So as stated in the notice of arbitration, the companies continued to meet with Marne and other government officials. Salvadoran officials continued to tell the companies that the issue would be resolved. They were also optimistic about the pending amendments. In the meantime, progress was being made on the company's other applications for environmental exploitation permits. In August 2007, Doric submitted EIAs for Waco and Pueblos. In November 2007, Marne provided observations on the Waco EIA and asked Doric to respond. In January 2008, Marne provided observations on the Pueblos EIA and asked for a response. January 2008. Also in January 2008, the majority leader of the Salvadoran legislature, a high-ranking official in President Saca's arena, told Mr. Schrake that he believed the proposed amendments introduced in the legislature would pass. He also believed the permits would be issued. Now, were the companies doing everything they could to get the permits issued? Yes. Did they hire lobbyists in San Salvador and in Washington, D.C., including at Crowell and Moring? Yes. Were they watching the legislative process in El Salvador closely? Yes. Did they think that the Saca administration had implemented or would implement a practice whereby the government wouldn't grant their applications no matter what? No. All of the company's actions were entirely inconsistent with any such belief. Why would Mr. Schrake be in San Salvador in January 2008 inquiring about the proposed amendments, how the proposed amendments were going to turn out, if he thought that the Saca administration had implemented such a practice? Or if the permit had been presumptively denied? And so it was indeed a shock when in March 2008, President Saca announced that he was opposed to granting any metallic permits. The Saca administration had always been, for the most part, very supportive of the companies. There was no reason to believe that the Saca administration was going to abandon the existing legal framework. Moreover, this March 2000 statement was a statement of the Chief of State of El Salvador. As President Funes later said, in El Salvador, the word of the president is the law. The comments were widely reported in the Salvadoran press, and they put the delays concerning the El Salvador applications in an entirely different light. In April 2008, Mr. Schrake wrote a letter to President Saca asking him about his comments and for the first time invoking the protections of CAFTA. On 25 June 2008, Mr. Schrake was able to get a face-to-face meeting with President Saca through the U.S. ambassador to El Salvador, Mr. Charles Glazer. That meeting was attended by President Saca, the Minister of the Economy, and the Minister of the Environment. It was also attended by Ambassador Glazer and the Economic Counselor at the Embassy, Mr. Don Allen Titus. In unrebutted testimony, Mr. Schrake summarized the June 2008 meeting. Mr. Schrake explained that President Saca told him that his statements were just political rhetoric and that he should meet with the ministers to work out the issue later that day. As explained in Mr. Schrake's witness statement, Minister de Gavidia, the Minister of Economy, didn't show up and resigned her position the very next day. Mr. Schrake and Minister Guerrero met, but they were not able to work out any agreement. Within a few weeks later, despite President Saca's supposed assurances to Mr. Schrake, he stated in much stronger terms than in the March 2000 statement that he would not grant any further mining permits. The headline stated, Saca affirms that he will not grant mining permits. So in July 2008, some 4 months after the March 2000 statement by President Saca, and having had a number of meetings with the Saca administration, the companies decided to shut down their drills and started to lay off employees. They laid off nearly 200 employees in El Salvador. They also laid off employees in Canada and the United States. And then in December 2008, press received a very puzzling letter from Marn. It's at tab 27 in your binder. This is not a letter that respondent has shown to you. Mr. Marn wrote to Mr. Ernest, who had been the president of press, and asked a series of questions about the proposed El Dorado water treatment facility. The subject of the letter was requirements for the water treatment plan for the El Dorado mining project. The concluding paragraph read, quote, once these requirements are satisfied, it will be possible to resolve your application for the environmental permit for your mineral exploitation project El Dorado, previously mentioned, within the 30 days following the date where you have finalized all the procedures of the assessment of the environmental impact. Now, we don't understand how the government can come before this tribunal and say that the El Dorado application was presumptively denied in 2004, or for that matter in 2007, when the government was sending letters like this in December of 2008. But I can tell you that when Claimant received this letter in 2008, in light of the statements that President Saca had made, in light of all the prior representations had been made, that Claimant concluded, quite fairly I think, that this letter was simply part of a ruse, of a double game that the government had been playing for quite some time. Claimant filed its notice of intent on 9 December 2008. On April 30th, 2009, it filed this arbitration. Now, these are the record facts. They are all unrebutted. Respondent has ignored them. Respondent has tried to obscure them, but it has not even tried to contest them. Now, my colleagues will take these key facts and put them in the context of the specific objections raised by respondent, but unless the tribunal has any questions, or unless the tribunal would like to take a break, I will turn the podium over to, oh, I'm sorry. Let me show you one more slide. This is Mr. Ali's favorite. And this is slide 17 of the PowerPoint. And this shows the investment that El Salvador, that the companies were making into El Salvador. And you will see that from 2004 through the March 2008 statement, through the alleged first presumptive denial, through the alleged second presumptive in denial, and so forth, the companies increased their level of investment. Now, why, if the companies believed there was a dispute, would they have continued to increase their level of investment into El Salvador? And with that, I'll conclude. Thank you.
Thank you very much. I think for the interpreters and the shorthand writer, we do need a break. So we'll take a break now, and we'll resume at 4 o'clock for the last hour of the claimant's oral presentation.
Mr. Chairman, I believe that we've used up 105 minutes and we have 75 minutes left.
We'll have an arbitration about that at 4 o'clock.
That began before entry into force and continued after entry into force are indeed covered. In other words, entry into force, or in this case, entry into force as to this particular investor, draws a line. And if you're on the line, if you're on the side of the line, if the measure at issue is on the side of the line before entry into force, then it's not covered by CAFTA's temporal scope. If it's on the side of the line after entry into force, then it is covered by CAFTA's temporal scope. So that then leads to the question, which side of the line are we on? What is the measure at issue? And the answer is straightforward, Mr. President. The measure at issue, and Mr. Degrand stated this earlier, the measure at issue is respondents' practice of withholding permits and licenses necessary for metallic mining regardless of the applicant's compliance with relevant laws and regulations. Now, we've come up with an appropriately descriptive shorthand for that measure because that is, after all, a lot of verbiage, and we describe that as the de facto ban on metallic mining. Now, let me be clear about something. That phrase, de facto ban on metallic mining, that's a label, that's a shorthand. We say it's an appropriately descriptive shorthand, and we may not have used that particular label or that particular shorthand in our notice of intent or our notice of arbitration to describe the measure at issue. But in substance, we've said the same thing. We've just used different words to describe it. The measure at issue is still what you see summarized on the slide before you, which is the practice of systematically withholding permits and licenses necessary for metallic mining, regardless of the requirements of Salvadoran law. Now, it is the de facto ban, it is that measure that is the basis for this dispute. That is what underlies claimant's claims in this case. That is the measure identified in claimant's notice of arbitration. Now, respondent challenges us on this point, but the notice of arbitration speaks for itself. And as an illustration, and this is just one place of many throughout the notice of arbitration where we've identified the measure at issue, I give you as an example paragraph 9, where we say, and I quote, "Only after President Saca's announcement in March 2008 did they," meaning Press and Dorex, "understand that they had become the target of something other than bureaucratic delay or incompetence. Rather, President Saca, without any legal or other valid reason, had simply decided to shut the enterprises down and deprive them of their substantial and long-term investments. As a result of the government's actions and inactions, the rights held by the enterprises have been rendered virtually valueless, and PRC's investments in El Salvador have been effectively destroyed." Mr. President, I submit that that is a clear identification of the measure at issue as what we call, as again, for shorthand, the de facto mining ban. Now, when that measure, when that de facto mining ban came into existence, is difficult to say precisely because it is an unwritten practice. It's not like a statute. It's not like a regulation where we can pinpoint the date of promulgation or the date of enactment. It is an unwritten practice that manifests itself through various acts and failures to act. It's difficult to identify when it actually came into existence, but the good news for the tribunal is that you don't need to decide precisely the date on which it came into existence. That question isn't relevant to the decision of whether you have jurisdiction ratione temporis. What is important for this purpose is that in March 2008, for the first time, El Salvador's head of state publicly acknowledged the ban's existence. In light of that fact, either the ban is an act or fact that came into existence at that moment, or to the extent that it was in existence before that moment and was just unknown to claimant or indeed any other investor, it is a situation that continued after CAFTA became applicable to claimant. In either case, the ban is a measure covered by CAFTA, and the tribunal has jurisdiction to consider it. Now, respondent, for this very reason, says the measure at issue is in fact not the de facto mining ban. The respondent tells you that the measure at issue is something else. Either it's a missed deadline in December of 2004, that is the moment when Marne should have acted on the application of Press for an environmental permit, or it tells you alternatively it was another missed deadline in January 2007. Now, yes, there had been missed deadlines, and yes, those missed deadlines were indeed frustrating to PACRIM Cayman and to the Salvadoran vehicles of PACRIM Cayman Press and Dorex. And yes, our notice of arbitration and our notice of intent discuss those missed deadlines, but it discusses them, or they discuss them obviously because they provide context for the claims at issue in this dispute. Just because we discussed those measures, and they are measures, we don't dispute that point, but just because we discussed those measures in the notice of intent and the notice of arbitration doesn't make them the measures at issue. The measure at issue, the thing on which our claims are founded, is still the de facto mining ban. Those pre-existing, those prior acts and omissions may indeed have been manifestations of that practice, but that only became apparent when the de facto mining ban came to light as such, which didn't happen until March of 2008 at the earliest. And I would submit, Mr. President, that the alternative measures that respondent has identified, in fact, cannot be the measures at issue. And that's so for three reasons, which I've listed here on this slide. Firstly, and most importantly, to be a measure at issue, a measure must be capable of serving as the foundation for a dispute. That's what it means to be at issue. It can't be at issue if the measure isn't the basis for a dispute under CAFTA. Now, CAFTA doesn't define the term dispute, but CAFTA uses that term frequently. And we'll put up on the screen one instance where CAFTA uses the term dispute, and that's in Article 10.15, which is the very first article in the portion of CAFTA Chapter 10 that deals with dispute settlement. And it says, in the event of an investment dispute, the claimant and the respondent should initially seek to resolve the dispute through consultation and negotiation. So what this particular clause makes clear is that for there to be a dispute, as that term is used in CAFTA, you have to have a claimant and a respondent. It is presumed that two parties have the respective statuses of claimant and respondent. And you can't have a claimant unless you have a claim, unless you have some view of your legal entitlement to particular rights under CAFTA. So a measure can't be a measure at issue. It can't be the foundation for a dispute unless it's capable of giving rise to a claim of breach of a CAFTA obligation. Not just a claim of breach of some obligation under municipal law. Not just a claim that a host state hasn't acted consistently with its municipal law, but a claim of breach under CAFTA. Otherwise, it can't give rise to a dispute as that term is used in CAFTA. And I would submit to you, Mr. President, that the measures that respondent has identified, the missed deadline in 2004, the missed deadline in 2007, could not give rise to a dispute as that term is used in CAFTA. They couldn't support claims under CAFTA. The missed deadline in 2004 didn't deprive the investments of their value. They did not constitute an expropriation. They may have been inconsistent with Salvadoran law, but they weren't a denial of fair and equitable treatment or an expropriation or a breach of any other obligation on the international law plane as opposed to the municipal law plane. And so for that reason, I would submit that those measures cannot be measures at issue, as that term is used in CAFTA. Now, the second reason that the alternative measures that respondent identifies can't be measures at issue, and let's go to the next slide, is that even if you give the most charitable definition to the term dispute, the broadest definition, even if you define dispute as respondent would define it to include not only disputes on the international law plane, but also disputes on the domestic law plane, on the municipal law plane, it still is not the case that the missed deadlines respondent identifies give rise to a dispute. They may have given rise to a difference of view between the parties as to what respondents' agencies should or should not have done, but a mere difference of views is not a dispute. For there to be a dispute, again, assuming that we're talking about a dispute whether under municipal law or under international law, for there to be a dispute, there must be something more than just a difference of views. And this proposition was articulated by the tribunal in the Maffezini versus Spain case. As the tribunal in that case put it, there must be a formulation of legal claims, their discussion, and eventual rejection or lack of response by the other party. Now, Marne's missed deadline in December 2004 did not result in a formulation of legal claims by PACRIM, let alone a discussion and eventual rejection of legal claims by El Salvador. Nor did MINEC's missed deadline in 2007 lead to these results. This is not a case like Mobile versus Venezuela, for example, where the existence of a dispute is evidenced by letters from the aggrieved party to the state claiming breach of an obligation and demanding satisfaction, demanding a process to remedy that breach. PACRIM's formulation of legal claims under CAFTA leading to a discussion with respondent did not come until the middle of 2008, after the existence of the mining ban came to light. Now, as I said, there's a third reason why respondents' articulation of the measures at issue cannot in fact be the measures at issue, and that is as a result of respondents' own conduct. And we've summarized that conduct on this slide and the slide that follows. But the main point here is that throughout the period from 2004 through 2008, officials at all levels of the Salvadoran government, including the most senior levels, repeatedly reassured press that the permits it had requested were forthcoming. In fact, they encouraged press to expand its investment in El Salvador, as Mr. de Grammont discussed earlier. A dialogue between Marne and press about press's environmental impact assessment continued throughout the course of 2005 and 2006. This dialogue cannot be reconciled with respondents' assertion that press's application for a permit had been presumptively denied as of December 2004 and that a dispute arose at that point. Even if the missed deadline meant presumptive denial under Salvadoran law, and that is a point we contest, Marne's continuing engagement with press caused press to rely to its detriment on the expectation that evaluation of the EIA was continuing. Likewise, expressions of support for the El Dorado project from the Vice President and the Minister of Economy throughout 2006 contradict any suggestion of a disagreement, let alone a dispute. As Mr. de Grammont discussed earlier, there was actually a visit to the Midas mine in Nevada in November 2006. That visit would have made absolutely no sense if, as respondent now contends, a dispute existed at that point in time. Now, even respondent appears to recognize the implausibility of its argument that the measure at issue is a missed deadline in either December 2004 or January 2007, and that a dispute arose when those deadlines were missed. Therefore, respondent tries to attack our contention that the mining ban is the measure at issue in other ways. And I'm going to just briefly describe some of those other ways and then get to the recent discussion of the Commerce Group case and how it might be relevant or not relevant here. One of the ways in which respondent has tried to attack our identification of the measure at issue is to insist that there was no de facto mining ban in El Salvador. You heard Mr. Smith say that earlier today. That position, frankly, seemed incredible to us in light of clear statements by President Saca and his successor, President Funes. But on closer inspection, it became evident that respondent was relying on a very strained and narrow definition of the term ban. And as I said earlier, when we use the term ban, we're using that as a shorthand. It's a label. The practice is what I described on the slide earlier. A ban is a convenient way of describing that practice. But under the definition of ban that respondent adopts, a ban would exist only if the subject conduct were prohibited permanently. If the prohibition were merely indefinite, even if that indefinite prohibition could go on for years or decades, the fact that it isn't described as permanent at the inception, in respondents' views, seemingly would mean it's not a ban. And I submit to you that that understanding of a ban simply doesn't accord with the ordinary meaning of the term. Under the ordinary meaning of the term, a prohibition of any sort is a ban, whether it's permanent or merely for some indefinite period. And in fact, in its reply, we can go on to the next slide. In its reply memorial, respondent actually admitted that a ban, as that term ordinarily is understood, does exist on metallic mining. That is, despite what the laws and regulations may require, the government of El Salvador will not issue permits for metallic mining for some indefinite period of time. Now, while respondent has tried to play down the existence of this measure, it hardly can deny it, given the widespread reporting of its existence in the 3 years since President Saca's statement. And on this slide, we've summarized some of the more explicit statements and headlines admitting the existence of the ban. Now, respondent has also tried to argue that Claimant did not allege the de facto mining ban to be the measure at issue in its notice of arbitration. But as I stated earlier, the notice speaks for itself and plainly refutes that assertion. Now, in its reply, respondent made a half-hearted attempt to show that PACRIM should have been aware of the mining ban's existence before 2008. And by the way, you'll note the contradiction between, on the one hand, trying to show that claimant should have been aware of the ban's existence, and on the other hand, denying its existence. I can't make sense of that. Perhaps the tribunal can. In any event, it made that point using press reports from 2006 and 2007 of statements by Salvadoran environmental ministers. But those statements were ambiguous at best. One, for example, was by a minister who later clarified that the views expressed were his personal views, not the official views of the Salvadoran government. Another was made in the context of an article about non-governmental organizations protesting against the government precisely because they, like PACRIM, understood that the government supported metallic mining. Thus, far from helping respondents' point, the article's respondent cited in its reply reinforced the point that claimant could not have been aware of the measure at issue until President Saca's announcement in March of 2008. Now, I want to spend a little bit of time talking about Commerce Group because, as the tribunal is aware, there's been substantial correspondence about the award in that case in the period since the briefing in this case closed. Respondent tells you that Commerce Group is absolutely on point, that it should govern this tribunal's consideration of what the measure at issue is and whether the de facto mining ban is indeed a measure at all, let alone the measure at issue. I submit to you that that award does not support respondent's position at all. The Commerce Group case was about El Salvador's, and we can go to the next slide, was about El Salvador's revocation of environmental permits previously granted to the investors in that case. As the tribunal in that case said, and you see it quoted here, it is undisputed that the relevant measures in this case and the El Salvador proceedings are the revocation of the environmental permits. The investors in that case challenged the revocations in local courts and failed to terminate the local court actions even after they had submitted claims to arbitration under CAFTA. And their failure to terminate the local court actions was blatantly inconsistent with the waiver obligation in Article 1018 of CAFTA. And on that basis, the tribunal dismissed Commerce Group's claims. Now, that was the main thrust of Commerce Group. The failure to terminate the local court litigation was the key fact that hung over that case. It is true that the claimant in Commerce Group made a separate argument based on what it referred to as the policy that led to the revocations. And it is true that the claimant characterized claims about the policy as separate from claims about the revocations of the individual licenses. However, and we can go to the next slide, however, the tribunal held, and I quote, the claim regarding the de facto mining ban policy, it held that that claim is part and parcel of the claim regarding the revocation of the environmental permits. It then said that the de facto mining ban policy claim is not separate and distinct from the permit revocation claims. The tribunal then went on to make a statement, and this is the paragraph that respondent focuses on. It went on to make a statement about what it would have found if the de facto mining ban policy and the revocation of the permits could be teased apart. But since it already had held that those two things could not be teased apart, this statement is obiter dicta. It is the definition of dicta. The tribunal is in effect saying, we can't tease these two things apart, but if hypothetically we could do that which we already have told you we cannot do, here's what we would have found. That is dicta. And indeed, it is dicta set forth in a mere 3 sentences in this paragraph 112 of the Commerce Group award. In fact, not only is it dicta, it is conclusory dicta. The tribunal gives no reasons for the distinction it's drawing between what it refers to as a policy and a measure, which is a defined term in CAFTA. There's no examination of CAFTA's definition of measure. You won't find in that paragraph any discussion of the definition in Article 2.1 of CAFTA. There's no attempt to apply that definition to the facts of that case. The tribunal, in fact, goes on to make a point of qualifying its own dicta by stating that it is limited to, and I quote, the tribunal's evaluation of this particular case. That's in the second sentence. Thus, the tribunal recognized that the conclusion it was drawing was based on a particular set of facts and arguments and should not be generalized. And in that regard, Mr. President, we should recall that the Commerce Group's tribunal's evaluation was pursuant to an objection under Article 10.20.4 of CAFTA, and therefore was confined to allegations in the notice of arbitration and undisputed facts. Unlike this tribunal, that tribunal did not have before it extensive evidentiary submissions. And, as if to emphasize this point, the tribunal went on to say in its last sentence, by contrast, the revocation of the environmental permits squarely constitutes a measure taken pursuant to that policy, and as noted, it was that revocation which put an end to claimants' mining and processing activities. That sentence plainly indicates that the tribunal's evaluation of the mining ban, as characterized in that case, was colored by its consideration of the ban by contrast to the revocation of the environmental permits. In the present case, there is no revocation of similar measure to serve as contrast in evaluating the mining ban practice that is the measure at issue here. One last point about Commerce Group before I move on, and that is that we actually agree with what the Commerce Group Tribunal says in that last sentence. That is that the act or omission that put an end to a claimant's mining and processing activities should be treated as the measure at issue. In Commerce Group itself, the act or omission that put an end to that claimant's mining and processing activities was the revocation of environmental permits. In this case, the act or omission that put an end to claimant's mining and processing activities was the de facto mining ban. It was not a missed deadline in December 2004. That didn't put an end to claimants' mining and processing activities. It wasn't a missed deadline in January 2007. That didn't put an end to claimants' mining and processing activities, as evidenced by the expansion of its investment after that date. It is the de facto mining ban, as confirmed by President Saca in March 2008, that put an end to claimants' mining and processing activities. In sum, nothing in the Commerce Group Award supports respondents' belated argument that the de facto mining ban cannot be treated as the measure at issue. Now, given limited time, Mr. President, I'm going to conclude with just a couple of brief remarks on statute of limitations and then on claimant's status as an investor of a party. Statute of limitations is easy because, as I said, it's essentially a mirror image of respondents' contention that the de facto mining ban is not the measure at issue. In other words, respondent is telling you either, or they're telling you that both, the measure is outside CAFTA's temporal scope, and therefore, as a consequence, a claim brought in April 2009 on the basis of that measure, not the one we alleged, but the measure that they allege we alleged, is out of time. It's beyond the 3-year limitations period. But precisely for the same reason that their argument with respect to temporal scope is wrong, their argument with respect to statute of limitations is wrong. In both cases, the argument is premised on a misidentification of the measure at issue. And in fact, their focus on the limitations provision in Article 1018.1 of CAFTA actually highlights their error in identifying the measure at issue as anything other than the de facto mining ban. What Article 1018.1, which we've reproduced on this slide here, tells you is that for CAFTA's temporal limitations to be triggered, there must be a breach and there must be damages. And it can't just be any breach. It's got to be a breach under Article 1016.1. In other words, it's got to be a breach of a CAFTA obligation or a breach of an investment agreement or an investment authorization. If it's not one of those things, if it's merely a breach of some obligation on the municipal law plane, then it doesn't trigger the temporal limitations delineated in NAFTA. And I submit to you that that is crystal clear with respect to the limitations provision defined in Article 1018.1, and that same rule logically applies when we're talking about whether the measure is or isn't within CAFTA's temporal scope. It goes back to the point I made earlier that for a measure to be at issue, or for it to be a measure at issue, it has to be capable of forming the basis for a dispute, as that concept is understood in CAFTA, meaning it has to be capable of giving rise to a claim of breach of a CAFTA obligation. Marne's missed deadline in December 2004 did not do that. Whatever else it may have done, whatever frustration it may have engendered, it did not constitute an expropriation. It did not constitute a denial of fair and equitable treatment. And indeed, as Mr. Ali said earlier, if you follow the theory that it did to its logical conclusion, it leads to absurd consequences where an investor essentially is required to protect itself on the international law plane every time there is a breach of an obligation on the municipal law plane. I know I'm moving through this material rapidly, and I know it's rather dense, but as I said, I'm doing it in the interest of time and to make sure that there's sufficient time at the conclusion of my remarks for my colleague to address abusive process. So let me just speak briefly on the question of claimant's status as an investor of a party. Respondent makes the argument, which it reduces to a mere 3 sentences in its reply, that the tribunal lacks jurisdiction because claimant does not meet CAFTA's definition of investor of a party. And that argument is based on the unsupported assumption that CAFTA mandates the sequence in which a person acquires the nationality of a party, number 1, and makes an investment in the territory of another party, number 2. In other words, it says you have to do it in that order. First, you have to acquire the status. First, you have to become a national. And only then can you make the investment into the territory of the other party. And if you do that in reverse, you're not an investor of a party. 2 points on that. Number 1, there is no such prescription in CAFTA. It's not in the definition that respondent showed you during the course of its presentation. It's just not there. There's nothing that says you have to do the operations in that order. Secondly, the argument that respondent's making is actually an argument that's been made by respondents in numerous cases. The 2 most prominent perhaps are FedEx versus Venezuela and African Holding versus DRC, where an investor acquires its investment on the secondary market from the person who actually put the capital or put the other assets into the territory of the host party, and respondent says, oh, you acquired your investment on the secondary market, just as Mr. Badini acquired his house from his mother through a gift. The fact of making the acquisition on the secondary market doesn't defeat the investor's status as an investor of a party. That's what the tribunal said in FedEx. That's what it said in African Holding. I submit to you that the same proposition applies here. With that, I'm going to take a brief gulp of water and pivot to denial of benefits. Yeah, Mr. President, Mr. Ali reminds me that before I move on to denial of benefits, I should first ask whether the tribunal has any questions on the jurisdiction ratio temporis.
We do, but not for now.
Okay. Okay, thank you. So denial of benefits. Now, in discussing of denial of benefits, I'm going to take the issues in a different order from our written submissions. I'm going to start with the issue of respondents' untimely notice to the United States of its intent to deny benefits to PACRIM. Then I'll turn to the subject of substantial business activities, and finally I will address the issue of ownership and control. I submit to you at the outset that under either of these grounds, the tribunal should reject respondents' belated attempt to deny benefits to PACRIM Cayman. I'm starting with the untimely notice issue because, frankly, that's a pure legal issue. The other two issues require some wading into to fairly fact-intensive questions, but there is no dispute with respect to the facts underlying the notice. And why don't we put up the timeline here? As this timeline shows, no dispute that respondent first notified the United States of its intent to deny benefits to PACRIM on March 1, 2010, in a letter addressed to the Office of the U.S. Trade Representative. Of course, it did not advise the tribunal or PACRIM of its intent until 5 months later, in August 3, 2010, but let's put that issue to one side. Now, respondents to the notification to the United States comes almost 1 year after Claimant filed its notice of arbitration. It came 15 months after Claimant filed its December 2008 notice of intent. It came more than 20 months after President Saca met with Mr. Shrake and the ambassador of the United States to El Salvador, not the ambassador of Canada, the ambassador of the United States to El Salvador, Mr. Charles Glazer, to discuss PACRIM's concerns, and after press reports indicated PACRIM was considering arbitration. So the question is whether respondents' delay in providing notice of its intent to deny benefits precludes it from stripping this tribunal of jurisdiction to consider the merits of PACRIM's claim. And I submit to you, Mr. President, members of the tribunal, that respondent is indeed precluded from doing that, from stripping you of jurisdiction by virtue of its untimely notice. Now, there's a related question of respondents' lack of notice or failure to give notice to PACRIM, but I'm going to focus my remarks on the untimeliness of the notice to the United States. And to understand why respondents' untimely notice defeats its attempt to invoke CAFTA's denial of benefits provision, it is important to understand the significance of the notice and consultation clause in that provision. Let's put that up. So the denial of benefits provision, which is Article 10.12.2, is made, and I quote, subject to Articles 18.3 on notification and provision of information and 20.4 on consultations. And as we pointed out in our written submissions, that subject to clause is extremely rare among United States agreements post-dating the North American Free Trade Agreement. That point is illustrated by this slide. Following NAFTA, the template the United States used in negotiating investment treaties and investment chapters of trade agreements did not include that subject to clause. The agreements based on that template generally do not condition the denial of benefits on compliance with obligations pertaining to transparency and state-to-state consultations. CAFTA does. Including that provision represented a departure from the prevailing model. In other words, the CAFTA negotiators went out of their way. They deliberately conditioned the denial of benefits on compliance with this notice and state-to-state consultations requirement. And I stress this point to highlight the significance of that subject to clause. The CAFTA negotiators chose to impose a procedural obligation on the denying party to avoid surprise invocations of denial of benefits, which is precisely what we have here. Yet respondent fails to acknowledge that distinction between CAFTA and other free trade agreements. On respondent's theory, the provision of notice of the intent to deny benefits to an investor's home party is simply a box that has to be checked at some point. Doesn't matter if it's done before the denial of benefits or contemporaneously with the denial of benefits. Doesn't matter if it's done before the submission of claims to arbitration or almost a year after the submission of claims to arbitration. But if that's the case, then there really is no difference between denial of benefits under CAFTA and denial of benefits under an agreement that lacks that subject to clause. And I submit to you that it's not the case that the CAFTA negotiators intended these provisions to be mere formalities. They are material conditions. They are key conditions. Now let's go to the next slide. Let's go to the one after this. So Article 18.3, which Mr. Badini discussed earlier today, requires a CAFTA party to notify another party of actual or proposed measures that might materially affect the operation of CAFTA or otherwise substantially affect the other party's interests. And we'll have more to say about this on Wednesday, but for present purposes, I submit to you that contrary to Mr. Badini's suggestion, that is not a choice. You don't get to choose whether you provide notice with respect to actual measures or proposed measures. You have to provide that notice whether the measure is actual or whether it is proposed. And I'll have more to say on that in our closing remarks on Wednesday. Now, it also requires the notifying party to promptly provide information and to respond to questions. The second subject to article is Article 20.4, and let's put that up. So 20.4 sets forth detailed rules for state-to-state consultations over actual or proposed measures or other matters that might affect the operation of CAFTA. In the denial of benefits context, it gives the investor's home state the opportunity to persuade the host state that the denial of benefits criteria are not met. In respondents' words, the home state can use that mechanism to show the denying state that the investor actually does have substantial business activities in its territory. Now, Mr. Badini said earlier, well, we gave the United States notice and the United States didn't avail itself of the opportunity to go to state consultations. Well, why would it? We're a year into arbitration. Do they really think El Salvador is going to change its position as a result of state-to-state consultations with the United States? Of course not. So it stands to reason that the United States to this point has not availed itself of that opportunity because it would have been futile at this point. Now, by making the denial of benefits subject to these provisions, Article 1012.2, let's go back to 1012.2. Article 1012.2 makes clear that the requirements of these provisions must be met in order for the denial of benefits to occur. If a party can deny benefits to an investor regardless of whether it has complied with the transparency and consultation obligations, then denial of benefits really is not subject to those provisions. Likewise, if a party can deny benefits retroactively, then the denial really isn't subject to those provisions. The phrase subject to makes compliance with the reference provisions a condition precedent to denying benefits. Since respondent failed to satisfy that condition precedent, it cannot now retroactively deny PACRIM the benefits of CAFTA, including the benefit of being able to pursue its claims through the present arbitration. Now, as we told you in our written submissions, not only is respondent's attempt to deny benefits inconsistent with the precedent, with the condition precedent in CAFTA Article 1012.2, it also is problematic in light of provisions of the ICSID Convention, and we identified two. We focused first on Article 27 of the ICSID Convention. And what Article 27 says is it prohibits a contracting state from giving diplomatic protection in respect of a dispute which one of its nationals and another contracting state shall have consented to submit or shall have submitted to arbitration. The problem is that CAFTA Article 20.4, one of the provisions in the subject to clause, envisages an investor's home state, here the United States, engaging in formal dispute settlement consultations with a host state, which could involve the giving of diplomatic protection. Now, that's not a problem if notice is given to the home state prior to the submission of claims to arbitration. In that case, the home state can engage in consultations, including by advocating on behalf of its investor, by showing that the investor has substantial business activities in its territory, by advocating, demonstrating to the host state that it is owned and controlled by nationals of that home state. But if notice of denial of benefits is not given until after claims are submitted to arbitration, the home state's ability to engage in consultations is severely constrained. It may not engage in advocacy for its investor because doing so may be seen as giving diplomatic protection in breach of Article 27. Now, respondent tells you that the giving of diplomatic protection is confined to the espousal of claims by an investor's home state. However, we have shown that, that the concept of giving diplomatic protection is broader than that. Espousal, or otherwise known as the bringing of an international claim, is dealt with in Article 27 separately from giving of diplomatic protection. To treat those two terms as synonymous would be to render Article 27's separate reference to the bringing of an international claim a nullity. And as we pointed out in our written submissions, the tribunal in Aguas del Tunari recognized that taking a stand on whether the tribunal had jurisdiction in that case could implicate the Article 27 obligation of the Netherlands, the investor's home state in that case. And in posing a question to the Netherlands, the tribunal was very careful. It crafted its question to avoid putting that state in the position where it might consider itself to be in breach of its obligation not to give diplomatic protection to its investor. And in responding to the tribunal's question, the Netherlands also was very careful, acknowledged its obligation not to give diplomatic protection, acknowledged that it wasn't opining on whether the tribunal in that case had jurisdiction or not. It simply provided factual information, didn't engage in advocacy, just provided factual information regarding the negotiating history of the instrument of consent in that case. And likewise, in other cases which I've cited on this slide, it's been recognized that the giving of diplomatic protection is something broader than mere espousal. And even if there's disagreement on this score, the possibility that the investor's home state may understand diplomatic protection to include advocacy will severely restrict its ability to engage in the consultations contemplated by CAFTA Article 20.4. So respondents' understanding of when a party is required to give notice of a proposed denial of benefits would put an investor's home state in an untenable position. Either it can advocate for its investor, engage in the formal state-to-state consultations referred to in CAFTA Article 20.4, and risk violating its obligation under ICSID Convention Article 27, or it can refrain. It can avoid engaging in those consultations, assure itself that it's not running afoul of its obligations under Article 27 of the ICSID Convention, but also in the end deprive its investor of the kind of advocacy that Article 20.4 of CAFTA envisions. In short, because of the restriction in ICSID Convention Article 27, respondents' understanding with respect to timing would negate the opportunity for state-to-state consultations on denial of benefits. Now, I said there was a second provision of the ICSID Convention that's also implicated by respondents' interpretation with respect to timing, and that's Article 25.1. As the tribunal knows, that provision prohibits a unilateral withdrawal of consent to ICSID jurisdiction. By purporting to trigger the denial of benefits after the submission of claims to arbitration, respondent is doing just that. And remarkably, in his remarks this morning, Mr. Badini essentially conceded that. I invite the tribunal to go back and look at slide 52 from that portion of respondent's presentation, where you'll see a statement, and I believe I transcribed this correctly, to the following effect. Once those benefits are denied to claimant, it has no right to submit any claims and does not have El Salvador's consent to arbitration. The key there is once those benefits are denied. The purported denial of benefits in this case didn't occur until March of 2010. So perhaps going forward, a claimant would be submitted, or this claimant would be would lack El Salvador's consent to arbitration, and might not be able to submit a new claim to arbitration. But the claim that was already submitted to arbitration has been submitted. It's only once the benefits are denied, which in this case occurred after the submission of claims to arbitration. Therefore, I think even respondents' own argument concedes the point that what they've tried to do here is inconsistent with Article 25.1 of the ICSID Convention. Now, respondent argues in its written submissions that denial of benefits is no different than an objection to jurisdiction that may be raised notwithstanding a party's originally having given its consent to the submission of claims to arbitration. I submit to you, Mr. Chairman, that there is an important difference, and the difference is this. When a respondent makes objections, jurisdictional objections, in the course of an arbitration, say an objection on the basis that the claimant lacks the nationality of a contracting state, it's doing that based on facts that existed before claims were submitted to arbitration. What respondent has done in this case is it's created an essential fact. It's created a fact that is critical, absolutely essential to the denial of benefits. Denial of benefits isn't automatic. What Article 10.12.2 says is that under certain circumstances, a host state may deny benefits. So when the circumstances described in 10.12.2 exist, we don't know whether benefits have been denied or not until respondent exercises that right. In other words, that's a critical fact. That's a critical jurisdictional fact. And unlike an ordinary objection to jurisdiction where all of the relevant facts predate the submission of claims, here respondent has created perhaps the most critical fact well after claims have been submitted to arbitration. And I submit to you that that's what distinguishes what respondent is doing here from an ordinary objection to jurisdiction. Mr. President, I'm now going to move on to the second two prongs of the denial of benefits article. As I said, I submit that if the tribunal wishes, it could dispose of the denial of benefits argument on the basis of respondent's untimely notice. In doing so, it could avoid wading into the much more fact-intensive issues of substantial business activities and ownership and control. However, even if the tribunal chose to wade into those more fact-intensive areas, I submit to you that the result would be the same. Now, in considering both substantial business activities and ownership and control, it is important to bear in mind why CAFTA contains a denial of benefits clause. As the parties state prominently in CAFTA's preamble, one of their objectives is to promote regional economic integration. Another objective is to ensure a predictable commercial framework for business planning and investment. Those objectives are advanced when an investor with a real and continuous economic link to one party makes an investment in the territory of another party. To encourage that kind of investment, the parties commit to provide the investor the protections set forth in Chapter 10. On the other hand, where an investor of a party lacks a real and continuous link to its home party, its investment in the territory of another party does little to advance regional economic integration. It does not bind more closely those two economies. Therefore, even though the investor is presumptively entitled to CAFTA's protections, because after all it is an investor of a party, CAFTA gives the host party the option of denying those protections to that investor. Now, the substantial business activities inquiry and the ownership and control inquiry ultimately get at this question of a real and continuous link. And I'm drawing that language, by the way, from what's called the Statement of Administrative Action that was submitted by the President of the United States to the U.S. Congress in connection with NAFTA. The explanation of denial of benefits is a little bit less robust in the CAFTA Statement of Administrative Action, but I believe both parties would agree that essentially the CAFTA clause was modeled after the NAFTA clause, and I think it's appropriate, therefore, to refer to the understanding of the corresponding clause in NAFTA, which focuses on that concept of a real and continuous link. And this underscores the point that the inquiries into substantial business activities and ownership and control are not meant to be mechanical inquiries. They're inquiries that need to be undertaken with that objective in mind. This is a point, let's go to the next slide, this is a point that respondent misses when it takes a quantitative approach to determining what kinds of business activities are substantial. It's a point that respondent misses when it insists on examining claimant's business activities outside the context of the corporate family of which claimant is a part. And it is a point that respondent misses when it chooses to disregard that a majority interest in the activities of PAC-RIM Cayman ultimately are held by U.S. persons. Now, in our submissions, we've shown that PAC-RIM Cayman has always had a real and continuous link with the United States. Although it was originally created as a Cayman Islands company, it always has been managed from Nevada by Mr. Shrake as part of the Nevada-based Pacific Rim family of companies. It is a holding company. We've never denied that. It engages in the kinds of activities that holding companies engage in. It holds and manages the investments of the group of companies in El Salvador. It holds and manages Pacific Rim exploration. It is engaged in just the kind of activities that the holding company claimants in the AMTO case and in the Petrobart case were engaged in. Now, respondent says that in arguing that claimant lacks substantial business activities in the United States, it is not making a criticism of all holding companies. It's just making a criticism of this holding company. But the distinction it's drawing appears to be based on this quantitative concept of substantial. So in respondent's mind, there is some threshold, some amount of activities that must be engaged in order for an investor's business activities in its home state to be substantial. We submit to you, Mr. President, that that is not in accord with the ordinary meaning of substantial, which is consisting of or relating to substance, nor is it in accord with the object and purpose of CAFTA, which I referred to earlier. After all, if an investor has to guess whether the quantum of business activities it's engaged in its home state are sufficiently large to ensure that it won't be denied protections by a host state, that certainly is not conducive to the sort of predictability that the CAFTA parties sought to achieve. I'm going to touch briefly on respondents' disregard of the family of companies of which PAC-RIM Cayman is a part. I submit to you that the tribunal will be able to find that PAC-RIM Cayman does have substantial business activities in the United States, whether it's looked at on its own or as part of the corporate family of which it is an essential part. But just to avoid any doubt on this subject, let me say a little bit about that context because I believe it's very important. As I said, PAC-RIM Cayman is part of a broader U.S.-based corporate organization. It doesn't operate in isolation. It doesn't operate in a vacuum. That distinguishes PAC-RIM Cayman from what one might consider to be a shell company. Now, that corporate family of which claimant is an essential part includes Dayton Mining, which engages in mining activity in Nevada, generating the capital that ultimately was used to make the investments in El Salvador. It includes claimant's subsidiary, Pacific Rim Exploration, which makes strategic decisions regarding which mining opportunities the companies should pursue, which also develops the intellectual capital about which Ms. McLeod-Seltzer has testified. And all of those activities are inextricably intertwined with claimant's own activities. So the idea here is not to attribute to PAC-RIM Cayman the activities of those other companies. It's simply to point out that the activities of this investor have to be viewed in context. You have to view this from an economically realistic point of view, which is no different from the way the tribunals looked at the investor in the Petrobart case, in the S.D. Myers case, or in the Aguas del Tunari case. So context, examination of the claimant from an economically realistic point of view, that's not attribution to the claimant of some other enterprise's activities. That is simply looking at this from an economically realistic perspective. And I submit to you that nothing in Article 1012.2 tells you not to examine this company's activities from an economically realistic perspective. I'll talk briefly about the subject of ownership and control and then turn the podium over to my colleague, Ms. Walter. We've submitted to the tribunal the witness statement of Mr. Passfield from Broadridge Financial Services, or Broadridge Investor Communication Solutions, demonstrating that in 2007, 2008, 2009, a majority of the shares of Pac-Rim Cayman's parent were held by persons with addresses in the United States. Respondent has chosen not to cross-examine Mr. Passfield, apparently doesn't contest that fact. Instead, it makes two arguments. Number one, it argues that indirect ownership and control of the claimant doesn't count for purposes of Article 1012.2. So if the ownership of claimant is indirect, if it is ownership by U.S. persons by virtue of their shareholding of the parent, that doesn't count in respondent's view. And secondly, they say just because these people have addresses in the United States, we don't know that they're U.S. citizens. Well, on the first point, on indirect ownership and control, Mr. Badini said it is claimant that's trying to rewrite Article 1012.2. That's not what's going on at all. As you see from the text highlighted here, Article 1012.2 doesn't refer to direct ownership or control. It refers to ownership or control, or in the verb form, own or control. So it is in fact respondent that is trying to rewrite this clause by insisting that the ownership or control that would defeat a denial of benefits has to be direct ownership and control. Simply nothing in the text that says that. Now, with respect to the citizenship of the persons who are the majority shareholders of Pac-Rim Cayman's parent, one quick point. It is inherently difficult to know the citizenship of the shareholders of a publicly held company. I think that proposition is axiomatic. And precisely because it is difficult to determine with any precision the citizenship of the shareholders of a publicly held company, we've proposed a rule of thumb. And we haven't just chosen that rule of thumb at random. It happens to be a rule of thumb that's applied by U.S. government agencies when they are confronted with this very same problem. There are U.S. statutes that make certain companies eligible for certain trade-related benefits. And from time to time, those benefits are conditioned on a company's being majority held by U.S. citizens. So the U.S. government agencies that are tasked with administering those statutes have posed this question to themselves from time to time. How do we determine whether the company, the publicly held company, is held in the majority by U.S. citizens? The rule of thumb that they have devised as a matter of administrative practice, which is spelled out in regulation as well as administrative handbooks, is they say if a majority of the shareholders have addresses in the United States, we will deem the company to be majority held by U.S. citizens, unless there's evidence to the contrary. And we would submit that because we're talking about a determination whether a company is held in the majority by U.S. citizens, because, as Mr. Badini said earlier, we need to refer to U.S. law. U.S. law is relevant here for making this determination. I would submit that equally relevant is the practice of the very agencies that are tasked with administering that law. And the agencies that are tasked with administering that law apply the rule of thumb that I've just described. I would submit that the same rule of thumb ought to be applied here. A last point with respect to control. Mr. Badini said earlier that because the parent company, the Canadian parent company, is the 100% owner, it controls Pac-Rim Cayman. And that assumes that there can be only one controller of a company. As the tribunal recognized in Aguas del Tunari, there's not necessarily one controller of a company. There may be multiple controllers of a company. And in fact, the shareholders of a company ultimately control it. It's to them that the board of directors is accountable. The board of directors can be removed by the shareholders, and therefore the assumption respondent makes that because Pac-Rim Cayman is 100% owned, is a wholly owned subsidiary of Pacific Rim Mining Corp., therefore it is in no sense controlled by the shareholders who ultimately can exercise that power, the ultimate power, to remove a board of directors. Therefore, they're not in control. That simply is an incorrect assumption, and I urge the tribunal to reject it. In the interest of time, I'm now going to turn the microphone over to Ms. Walter. Should the tribunal have any questions, of course, on denial of benefits, I'm happy to answer them now.
We'll put them to you later. Thank you.
Thank you.
Thank you, Mr. Chairman and members of the tribunal. We're all very interested in time now, so I'm also going to, in the interests of time, try to make this brief and just make a few points on abusive process. As I think we've understood by now, the question of whether there has been an abusive process in this case really turns on one critical fact, and that is whether the dispute arose before or after Pac-Rim's change of nationality in December 2007. Now, we have shown you that, in fact, the dispute did not arise until, at the earliest, March of 2008. And we submit that if you find that that is indeed the case, there can be no finding of abusive process here. But to be clear, Pac-Rim Cayman does not have the burden of proving that it brought this claim in good faith. Respondent bears the burden of proving its abusive process defense. And if you'll show the first slide, that was recognized, for example, in the Chevron case, where the tribunal noted that a claimant is not required to prove that its claim is asserted in a non-abusive manner. It is for the respondent to raise and prove an abusive process as a defense. And this is important because some of the same facts that are at issue with respect to respondent's objection ratione temporis and its objection as to abusive process are at issue, and particularly the timing issue. But when it comes to finding an abusive process, you must look to respondent to prove all of the facts that it has alleged. And as we noted in our written pleadings, a finding of abusive process is actually quite extraordinary. Even the Phoenix case, on which respondent relies, shows that the tribunal, as I'm sure Professor Stern knows better than anyone else here, did not dismiss the case for abusive process per se. It dismissed the case because there was not a foreign investment, no bona fide investment by a foreign investor. And they found that it would be an abusive process to entertain the claim. And we submit that the paucity of cases that actually find abusive process, including the utter lack of any decision dismissing all claims on that ground alone, reflects the fact that a heightened standard of proof applies to an accusation or an allegation of abusive process, which is, after all, an allegation of bad faith. If you think back to this morning, think of how many times we heard respondent talk about things like concealment and deceit. Those kinds of allegations must be proven by more than a preponderance of the evidence. They must be proven by at least clear and convincing evidence. Mere supposition and innuendo and notations of so-called coincidences do not suffice. And I think it is clear from what you've heard today and what you will hear for the rest of this week, respondent has come nowhere near establishing any of the facts that it has to prove by clear and convincing evidence in order to prevail on its theory of abusive process. The only witness it has produced on claimant's motivations for the change of nationality, which is the core of its abusive process claim, or defense, I should say, is one of its own attorneys, who testifies to what he speculates may have been in the minds of counsel for claimant several years ago. But this is irrelevant to the issue of when the act by the government of El Salvador occurred, or when we gained knowledge of it, such that a dispute arose. And that did not occur until early 2008, after the change of nationality. And I would further note that respondents' allegation of abuse of process goes beyond just the timing issue, although that is the key issue. There are actually several related facts that form part of respondents' theory, and if you'll go to the next slide. I think I have approximately 8 minutes or less, so I'll make this quick. Respondent alleges first that there's an investor with no ties to the U.S., that's Pac-Rim Cayman. But as we've discussed earlier today, and particularly in Mr. de Gramont's presentation, but also my colleague Mr. Posner's, Pac-Rim Cayman has always been managed and controlled from the U.S. It has long-standing ties to the U.S. It is part and parcel of an enterprise making an investment in El Salvador, directed mainly from the U.S. Second, that this investor with no ties to the U.S. set up a shell company with no substance in the U.S. Now, Pac-Rim Cayman is not a shell company because it does hold and manage significant assets. It makes strategic decisions as to those assets through a U.S.-based manager, and it has incurred liabilities. A shell company, by definition, does none of those things. It's not a shell company. Now, we've also discussed to some extent the fact that its activities have substance. They are substantial activities. So that's also not proven. And in fact, quite the opposite, we would say, has been proven. And third, that it did all of these things for the sole purpose of obtaining jurisdiction over a pre-existing dispute. Now, as I've already mentioned, it was not a pre-existing dispute. Yes, there were delays. And as we've already acknowledged, yes, that may have caused frustration. There was continual dialogue between Pac-Rim Cayman and representatives of the Salvadoran government over how they could work their way through to a solution. But there was not a legal dispute. Not until President Saca acknowledged, or revealed rather, the existence of what we call the de facto mining ban. Again, March 2008, after the change of nationality. And finally, respondents' theory rests on the belief or the allegation that there was otherwise no access to international arbitration, no ICSID jurisdiction for the claims to be heard, and this is the motivation behind the alleged abuse. But as we mentioned earlier, the companies could have submitted claims to arbitration either under CAFTA through the U.S. investors who owned shares in Pacific Rim Mining Corp, or through the investment law. So that prong isn't met either, and again, quite the opposite. We believe we have proven that it can't be the case, although it is not, again, not our burden to show those things. 4 minutes. I'll just quickly contrast this case with Phoenix again in a little bit more detail. Now we heard, it's interesting, we heard this morning from counsel for respondent that Phoenix action wasn't really about a domestic dispute, or that's not really important because it cited Banro and some other cases. But Banro didn't involve an allegation of abuse of process. Phoenix did, and it was key to the tribunal's decision, we submit, that it was actually a domestic dispute. There had been litigation, there was ongoing litigation in the Czech Republic already happening when the owner, or one of the owners of those companies, fled to Israel, formed the claimant, and then submitted a claim. And the claimant was only created after the dispute and the damages had occurred, not what we have here. Our claimant has existed for a long time and changed nationality before the dispute arose. Third, the investment was made, quote-unquote investment was made by the claimant only after the dispute and damages had occurred. That's when it bought its interests in the Czech companies that had the litigation. That's not the case here. There was significant foreign investment that occurred before the dispute arose. And again, Pac-Rim Cayman was a U.S. national before the dispute arose as well. Finally, and I think this was also very important to the tribunal's outcome, the investment, and again I put it in quotes because the tribunal found it wasn't a genuine bona fide international investment, was accomplished through transactions that did no more than rearrange assets within a family. It wasn't really an investment at all. It was a way of trying to dress up a domestic dispute as an international dispute. And we have nothing like that here whatsoever. It is a bona fide investment. And then I think we have one more slide just to bring home that point. The tribunal in paragraph 97 of Phoenix explained its concerns and what we believe really underlay its decision as follows. The BITs are not deemed to create a protection for rights involved in purely domestic claims, not involving any significant flow of capital, resources, or activity into the host state's economy. This is why, number one, there was no real investment, and this is why it was an abuse. It was a domestic dispute. There was no investment. That's not what we have here at all, we submit, and we can certainly answer your questions more likely on Wednesday, I would think, than now, but we stand ready to do so. Thank you.
Thank you very much.
Mr. Chairman, given that we would not do justice to the investment law in a minute and 90 seconds, we will rest on our pleadings and address any submissions that are made by respondent on Wednesday.
Well, you can take it. We'll read for ourselves what you've given us in the form of the slides in regard to the investment law. But we'll come back to it, no doubt, later this week. Unless there's anything else either party wishes to raise, we'll adjourn this hearing until 9 o'clock tomorrow, when we resume with the two witnesses on the agenda. Is there anything anybody wants to raise? I'll ask the respondents first.
Nothing from El Salvador.
And from the claimants?
Nothing from claimant, Mr. Chairman. Thank you.
Until 9 o'clock tomorrow. Thank you very much.